Item 9. Are you filing any affidavit?
In respect of others, they have already provided the amount, refunded the amount. For ours,
On the prayer for adjournment made by Mr.
along
B. Gogoi, which is not objected to by Mr. B. D. Das. List the matter.
9 and 10 both.
Okay.
This matter has led by and for the respondent. Led by Mr. James. Very good. When you put Mr. Other matters, liability matters is difficult.
What is there? I'm thinking of
31.
Mr. Counsel. What remains in this case?
I number 13, my lord.
Okay, yeah, 13. Why are you asking for adjournment? I don't
But I'm for a.
There are other cases also. He's not going to appeal any.
This matter came up on the concept of yesterday.
The facts have been proved by way of a field verification. What more? There's nothing else to decide. This purely a question of fact. It has been. What better proof do you want when a person has specifically gone and seen it?
I totally agree, but I cannot go beyond the instructions of a client resolution. They want to argue.
Here for whom?
I put a responsible to the company.
You have also been asked to demolish a part of your building.
No. That matter is item number 13.
13. Ah. Okay, that's it. Okay, right. On the prayer for adjournment made on behalf of respondent number 2, which is not objected by the counsel for the petitioner. This is the matter. After?
On 21st, my lord. 21st May.
When do you want? You all decide.
It's 21st May, my lord.
Huh?
21st May.
21st May.
Highly obliged. Item number 5. Another not recorded whether the rate of Srinagar district is actually clear or not. Now the documents which is submitted was based on record. It doesn't display the rates of Srinagar.
Where is the other side? Have you taken the consent?
Then what happened finally on 29, just on 29, we received the full instruction. It says that the rates are actually displayed. We have said all these things are accepted and this being filed right now. Yesterday the holiday manner.
I have not received it yet, man.
It is being filed. The officer has shown it.
You have filed it without giving a copy
It is
to the petitioner.
being filed right
It is being filed, but how can it be? How can that process even be initiated?
now.
It is being filed. That means it's somewhere here. Then you give it to him.
Process is going.
Process going on.
The copies are being taken.
My lord, after week, my lord. In the
Okay,
meantime,
right. Mr.
LNG.
No, not you. P. Bhardwaj appearing for IOC. Respond number 4. Submit that affidavit is being filed today. Accordingly, on the prayer made on behalf of Mr. P. Bhardwaj, Mr. L. Dihingia, which is not objected to by Mr. G. N. Sayawala, learned senior counsel. List the matter on 10. No. Huh? Next week will be pretty heavy. After that, huh? What is your case? Your case is now in favor of them. Earlier it was in favor of somebody else.
Their paper.
Now it's in their favor.
where is it? Actually, it's set up with them.
Yeah, okay.
Nine, Lord.
Ninth, we've got the full bench. No, not possible. We have fixed too many. After the week after that.
After that, Tuesday.
Tuesday, what is that date? 14th.
Okay.
Item 5.
Lordship, may I pray for the listing of a writ petition for withdrawal, Your Lord?
Tomorrow.
May I please, my lord, I beg to mention for listing of a IA, my lord, stay vacating.
Regarding
Stay vacating, my lord.
stay vacated.
Yes, my lord. The matter is, my lord, the settlement of fishery, my lord. Kindly list on Monday or.
Okay, Monday.
Most of the.
May I please, Lordship, I beg to mention for listing of a writ petition, Lordship. May be listed by 10, Lordship.
Huh?
10, Friday.
What? No. Listing of a new petition, new writ petition. What is the ground? What is the urgency?
It is regarding, Lordship, granting of the arm license, Lordship.
Arm license. Arm license, I don't. know. You have applied for arm license
Lordship.
and you have not been given the arm license.
No.
Okay.
Therefore, listing a writ petition, Lordship, for admission, Lordship. Lordship, we have filed our reply. I am for the respondent side. We have filed our reply. Let it become for admission hearing.
Give a date.
21st.
Obliged.
14 for withdrawal.
May I please, Your Lordship? The petitioner is no longer interested to press the matter, Your Lordship. The matter of-
Okay, Mr.
I.H. Lordship.
Ayush Laskar submits that he has received instructions that the petitioner would like to withdraw the writ petition as he is not interested in pursuing the matter. Mr. J. Handik appears for the Revenue Department. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn.
High level. This is third occasion, my lord. Your lordship may kindly see page 122.
122. Yes,
These are the two vehicles, my lord. It was placed before the authorities on 23/3/24. After your lordship's order at page 116. There is a delay of about 6 days in delivering the vehicles. Now they are saying that it is terminated. My lord, only one aspect. Your lordship's order is at page 116. But before that, I would like to point out one or two things, my lord. Your lordship will kindly see page 83.
page 83.
Yes. This is the notice of award. This is for two, my lord, ambulance service vehicle, my lord, at Bongaigaon Refinery. Second line here, lordship will kindly see, second paragraph. Contractual time of completion is for 3 years from the date of handing over of site. This site was never handed over to us. Please refer so and so. In line with so general clause condition of contract, you are requested to deposit initial deposit of rupees so and so. All this amount has been given. Now page 84, your lordship will kindly see. This is the letter of acceptance from our end. This is the work order, my lord, sorry. Page 84.
Letter of acceptance is not issued by them, not by you.
No, it is by them. It is 84, man. Page 84, hiring, subject your lordship, hiring and operations of ambulance services at Bongaigaon Refinery.
Where is the subject?
Hello?
Where is the subject?
Subject is this, my lord. Hiring and operations of
yes.
ambulance. Next page, your lordship will kindly see. time period as per GEM contract number so and so. Has your lordship got it? Second page, on page 85.
Yes.
Then terms and conditions is all terms and conditions shall be governed by six, serial number 6. Terms and conditions, all terms and conditions shall be governed as per GEM contract. Now your lordship will kindly see page 87. This is the GEM contract.
87 is the GEM code.
GEM contract. My lord, in about my lord, below my lord, your lordship will get my lord about 6 inches above my lord. Service start date.
Yes.
Has your lordship got it?
Yes.
Service start date is 18/1/24. Period of service is we are required to give it in 2 months from the date of this my lord, and service end date is 27. So if the date is 18/1/24, I am late by about 6 days because we have supplied the vehicles, 2 vehicles on 23. On 23/3/24. And now your lordship will kindly see what is this vehicle, my lord? What is the vehicle to? Details to?
No, how can it be? How could you supply the vehicles on 23 how you supply the vehicles on 20?
3. But my lord, it expired on 17/1. 17/3. 17/3. Because a contract period starts from service start date is 18/1/24.
Correct.
So 18/1 means after 2 months, my lord.
So you are late by 2 months.
No. Say 6 days.
14/1.
Huh?
14/1.
The service the service is to start from 18/1.
Page 7.
You delivered the vehicles only on 23
2 months.
after 2 months.
Yeah.
So how can it be 6 days late? It's 2 months late.
Page 70.
Page 70, your lord.
2 months.
2 months here. Not
You are late by 2 months.
No.
How?
Late by 6 days. I'll explain.
Yes, please. Page 70?
Page 70, clause 14.
70.
70.
Yes.
Here, condition of contract, my lord. My lord, 14.1, penalty. If the contractor is not able to place the ambulance according to the specifications, model, this is a special vehicle, my lord, immediately within the specific time period of 2 months. So, work
From the date
order,
of 2 months.
yes.
So
So,
LOA was issued when?
LOA was issued, my lord, work order was issued on 1/1/24. 2 months,
1/1/24.
24.
So
But it
2
will
months
start-
2 months will go on, will 1/1/3/24, 2 months will expire.
No, but work order should be in GEM is 11/1/24. And we have to follow the GEM contract. Man.
I don't know. Work order issued when?
Work order issued in GEM is 11/1/24. And it says that starting date is 18/1/24.
11/1?
24.
No, starting date is different. Starting
It
date
says
is?
so. 18/1/24. Now your lordship, I'll just read
No, you
this.
see, the starting of the work might be different, but the placing of the ambulance is again different date. That's
No,
all.
2 months, my lord. Starting date of the GEM is contract period. So
No, Mr. Counsel, at page 70, it says that if the contractor is not able to
Well,
place the
I'll just read
ambulance,
this paragraph, and it's important.
so
I'll
the
read this
placing of the ambulance has to be done within 2 months.
No, yes, but before that, I'm required to.
The running of the ambulance may be a separate date, but the placing of the ambulance has to be within 2
2
months.
months, but the start of the contract date is 18/1. Otherwise,
Maybe.
as per them,
Maybe.
my lord, yes.
Maybe.
As
But-
per them, I'm late by about 11 days or so, my lord. But as per me, it is 6 days.
Whatever.
That's a different matter. My lord, your lordship will kindly see 70. I'll read this. This is important clause for me.
Page?
That's 70, 70.
Yes,
14.1, if the contractor is not able to place the ambulances according to the specifications immediately within the period, specified time period of 2 months from the date of placement of the work order or LOA as per terms and conditions of the contract. Terms and condition of the contract is GEM. The agency may make alternate arrangement of providing ambulances of model not older than 2020 for a period of maximum up to 2 months. During which we are providing. During this period, the payment on rent of the ambulances to be paid to the agency shall be reduced by 5%, 10% and 15% of the accepted rates for providing of ambulance services at Bongaigaon Refinery. These two ambulances, we are placing it and they are running it. Now, second is important. In case the agency fails to provide the ambulances within the specified time period of 2 months, the contract may be terminated at the sole discretion of the OACL and therefore they have terminated. However, the ambulance services may be continued till lining up of the new agency with the higher rates such as 10%, 15% and 20% against the model number so and so. In this regard, decision of IOCL would be final and binding upon the agency. Because of this, my lord, now what they have done is they are continuing the half, they have terminated my contract after getting the ambulance and they are saying that you will run the vehicle at the reduced rate, not at the highest rate. That there will be an increase of the rates.
they will run which vehicle? The new vehicle?
Not few,
The old vehicle?
old vehicles. They will continue to run
So
that.
what is wrong? This is part of the tender clause.
No, the part of the contract, but when, my lord, there is a delay of about few days, my lord, then, my lord, this is too harsh a decision for, my lord, terminating the contract. My lord, I'll just place one decision in this regard. These are MSME unit, MSME unit, they have taken a loan of 55 lakhs and there was these are special vehicles. It takes time because it comes from the manufacturers. So they cannot be harsh. One decision I got, my lord, here.
But then can you say that the terms of, are you challenging the terms of the
No,
tender?
I'm not challenging, my lord, but there it says may terminate, but in this case, my lord, 2023 2 SCC, there was a delay of 56 days in commissioning the project. It was terminated. Yeah. 2023 2 SCC. This is too harsh a decision, my lord.
I don't know if, I do not know whether, because this is basically as per their discretion.
Yes.
Let us see what the
No,
court
as
says.
per the terms, yes. My lord, paragraph 1, your lords will can see it is 703. If this is the attitude taken, my lord, no MSME will be able to survive.
But then you are bound by the terms and tender from the
Terms and
condition.
conditions it says, my lord, but at the same time, my lord, delay of 5 days or 6 days will not make the contract back.
How many tenderers were there?
My lord, first tenderer and second tenderer. Yes, because, my lord,
How
this is
many how many bids were there?
the two were selected. I was the L2 and the L1 was there. Split contract, my lord. 60% of the contract.
So you see, L1 has no problem in
L1 also
providing.
did not give anything. L1 also did not get it. And second, your lordship will kindly see that page 70, the terms and conditions, if it is terminated and in the old
Let us
pages,
see, yes, where is it?
yes, page 703,
Yes.
70. Here also, there was a delay of 56 days in commissioning of the project. That was terminated, that was set aside by the High Court. Ultimately, your lordship will kindly see paragraph 1. Oui. Oh, God. It starts from 729. The appellants impugns the judgment of the High Court dated so and so. It further challenges the order dated 28/12/2020. By the said judgment in the writ petition, the High Court allowed the writ petition filed by the first respondent and quashed the order dated so and so, which was passed by the appellant, terminating the power purchase agreement, which was entered into by the appellant and the respondent. The review filed by the appellant was also dismissed. Facts is, my lord, paragraph 2. The appellant, which is a wholly owned company of the government of Madhya Pradesh, is responsible for the bulk purchase of electricity in the state of Madhya Pradesh for onward sale and purchase of the distribution utilities. My lord, now second paragraph, your lordship, paragraph 3. The agreement contemplated completion of the conditions subsequent within a period of 10 days. In other words, the agreement admittedly provided that the first respondent was to achieve fulfillment of the conditions subsequent by 15/4/2016. The agreement further contemplates an extension of the period of fulfillment of the conditions subsequent on payment of penalty for a further period of 9 months. Thus, calculating 210 days and an additional 9 months from 18/9/2015, which is the date of the period, would come to an end on 15/1/17. Now, paragraph 5, third sentence, fourth sentence, it is paragraph 5, it is interiorly pointed out by the appellant that the first respondent had no document in regard to 34.12 hectares of land and an unregistered. They were required to have land, there was delay in procurement of the land. This did for only 12 months, which was submitted. Thereafter, it was stated that PPA is liable to be terminated in terms of Article 2.5.1. Explanations, justifications, if any, was called for from the respondent. Acting on the request of the first respondent, the appellant granted time for response of the first respondent till so and so. The response which was given on so and so reads as follows. Now, your lordship will see paragraph 9.
At best, we can issue notice.
My lord, unless it is, my lord, suspension is there, my lord, they will issue, my lord, NIT and this.
That NIT can be stayed. That is not a.
This
Yes,
ambulance,
what is that?
these ambulances are lying there.
Just a minute. Yes,
Case number of
62, yes. Yes,
terms and conditions. After
My lord, I just wanted to point out paragraph 9 of the petition, that case, my lord.
just a minute, yes.
the subject to effective and subject
No, where are you reading? Page 62, which? Huh? Page 62, yes. Where? Which part of page 62? Huh? D. Okay, yes.
of
Page 94.
the context or eligibility and subject of the within 7 days. Lordship, then lordship, come to case number. One 39. Notice before 139.
Yeah.
As per clause 4(1), you will submit in office of
Just a minute, just a minute. This page 139, yes. Which para? Second para, okay, yes.
Has failed to submit in time, hereby non-compliant and has violated the contractual terms and conditions of the contract. As per terms and conditions of the contract, clause number 41, you were to provide 2 new ALS ambulance model 23. It is specified time period of 2 months from the date of development for the alloy, which you have failed to comply hereby has violating the terms and conditions of the contract. And during the meeting held 29/1/2024, today also be advanced before two new ambulance as per context terms and conditions of the contract. However, order the MOM contract for meeting. But as per Procedural 64/701 and Circular has to change section for work or and time according to the contract. so not that they violated the terms and conditions of the.
Well, you will issue notice.
My lord, your lordship will, yes, your lordship will, if your lordship issues notice, my lord.
Huh?
Two conditions, my lord. One, my lord, on this, my lord, let me just reply shortly, my lord. Page 93, your lordship will, can you see? Page 93. This we have stated that we have booked the vehicle on 6/1/24. And we have informed them verbally, my lord. This is because regular, that is there, but if, my lord, if I have not
You
booked
see,
it,
when the
Condition is there
clause,
to
when the
inform.
clause requires to submit proof of booking,
yes,
verbally will not work.
no, I'm submitting, my lord, because if they would, if they would have asked me, my lord, they should have asked me after 10 days itself. Have you booked the
No,
vehicle?
no, Mr. Counsel, you cannot say that some parts of the clauses of the contract will apply to you, some will not apply to
No,
you.
I'm not saying
That's
that.
what you basically
What
say.
I'm saying is that, my lord,
Right,
we have
Mr.
booked the
BD.
vehicle, and second, my lord, your lordship will kindly see, in terms of the termination order, it totally overlooks the provision of clause 14.1. That impugn order, your lordship will kindly see.
Heard Mr. BD Das, the learned senior counsel for the petitioner.
My lord, page 139
submit.
is the impugn,
That the impugned
is page 139. What I am saying is,
termination of contract
not only
by
termination,
letter
it says
dated 20/04/2024.
it will continue with the old vehicle at the old rate. That is reduced rate. That is wrong, my lord.
Should be set aside. The the petitioner's counsel submits that the contract has been terminated on account of the petitioner not having submitted proof of booking of the vehicle within 7 days after receipt of the LOA/work order, and for not submitting and for not providing the two new ALS ambulances /model 2023, BS dash Roman 6 within 2 months from the date of placement of the work order/LOA. The petitioner's counsel submit that the petitioner having submitted his having provided the two new ambulances after 6 days after the
Jam conflict.
provided 6 days after the period provided. The period provided by the respondents, the 6-day delay should have been condoned by the respondent. Okay. Issue notice, returnable in. You're the only
Short
one, I
date
think.
may be given, my lord.
You're the one. So, issue notice returnable in 2 weeks. Miss, accept notice on behalf of the all the respondents. All the respondents. List the matter. No, the respondents are the response counsel is to obtain instruction and file affidavit if necessary by the next day.
Attempt may be,
Leaves the matter on, give a date.
my lord, no NIT should be issued in this.
No. That does not give anyone any right anyway, NIT.
My lord, if they issue fresh NIT,
They will see when the term comes.
but at least the status quo as regard this.
No,
subject matter.
next.
But this, your lordship may interfere, page 139,
What?
that your lordship will kindly see, they will, paragraph 1,
No, I'm not interfering with anything. Next.
that is on the face of it in violation of 14, my lord. Obliged.
Yes.
May please your lordship. This matter pertains to procurement of certified seeds by the Assam Seed Corporation. but on particular NIT, two clauses of the NIT is under challenge in this writ petition. Now, may I take your lordship to the NIT at page 26.
Page 26, yes.
26, this is the NIT. For procurement of fresh certified seeds of different crop varieties for the year 2024-25. Now, my lord, before I take your lordship to the, my lord, the offending clauses, may I take your lordship to page 31? Page 31, your lordship will find clause Roman 2.
Yes.
Open competitive bidding method shall be followed for selection of most preferred bidder for the tender items. The tender item conditions and procedures are in conformity with the Assam Public Procurement Act 2017 and the Assam Public Procurement Rules 2020 as amended from time to time. Why I am pointing out this is that, my lord, I will show and satisfy your lordship, my lord, this is not in terms of the my lord, procurement rules. Then the last date was 28th of March. But then, my lord, there have been 3 corrigenda thereafter. And the last date has been extended, and today is the last date for filing of my lord, tenders, bids. Now, the offending clauses, your lordship will find at page 63.
Now, what do you want to show me with page 31?
That, my lord, they have to confirm, they purportedly they claim that this is in conformity with the some state procurement rules. That is what I wanted to show.
Page 63.
Now, my lord, page 63. These are the clauses, my lord, by which the petitioner is offended. Qualification criteria. Clause 4.2. Now, clause 4.2.1 is the required minimum experience. And 4.2.2 on the next page is regarding, my lord, the financial standing. If I may read, my lord, for 4.2.1, required minimum experience. The bidder must have experience of supplying certified seeds to the government departments, undertakings, entities, PSUs to the extent of at least 20% of the estimated quantity for scheduled item, that is against its particular crop in the certified seed business during 2019-20 to 2023-24, 5 years, till the last date of submission of bid. Then clause 2, the bidder must have experience of supplying TL seeds, that is, my lord, truly certified, truly level, my lord, truthfully level. Seeds to the government department, undertaking, entities, PSUs to the extent of at least 20% of the estimated quantity for scheduled items against each particular crop in the TL seed business during the last 5 years. Then next page, your lordship will find the financial standing. The bidder should have at least an average annual turnover of rupees, as mentioned in the table below, 20% of the quantity for the scheduled item, that is against each crop during the last 3 financial years, that is 22, 21.
Just a minute. What is the difference between this subclause 1 and 2?
In, my lord, clause 4.2.1.
Yes.
This is, my lord, they are asking experience to the, in the first clause, my lord. The experience of supplying that particular seed, my lord, for the last.
Okay, certified
Right.
seeds and TL seeds are different.
Yes, my lord.
Okay. Then
Then, my lord, 4.2.2 at page 64. The bidder should have at least an average annual turnover of rupees, as mentioned in table below, 20% of the quantity of schedule of items during the last 3 financial years, that is 22, 21, 21, 22, and 2023 from any business. This is important, my lord.
The bidder should have at least an average turnover of rupees what, as mentioned here below. Yes,
Now, for the financial standing, the amount that is, my lord, required to be calculated can be, my lord, from any business.
from any,
From any business, last two words, my lord,
from any business.
from any business. Now, my lord, my submission.
From any business, but it will have to be in conformity with this tender, not something say motor vehicles or automobiles cannot come in.
That is what I was trying to.
Trying to say
Yes, my.
that anything, even if he's doing rocket engines, that would come in.
Yes, that is what it says, my lord.
I doubt.
And because, my lord, if that is so, my lord, if it is from.
If that is so, then you come in.
No, my lord, I
Huh?
don't come in.
Okay, you
And
don't
my
come.
lord, my submission before your worship is that I am a registered contractor.
Huh.
My lord, I have got the license from my lord, the department.
Huh.
With stringent license, my lord, what are the items I can my lord, supply?
Huh.
And my job is to get it from A and supply it to B.
Huh.
A is the producer of the seats, and B is my lord, the requiring department. So, my lord, I do not come in as far as the quality of that is concerned. My lord, the certificates are issued by my lord certified authorities. There are agencies other than in the seats act. So, my lord, my only job is that I procure it from my lord producer.
So how does 4.2.2, how is it to
my
a
lord,
detriment?
My submission before your lordship in this case is that these two clauses are restrictive and it does not, my lord, conform to the purpose sought to be achieved. Because, my lord, so far as my financial standing is concerned, to the extent, my lord, I can participate it, and I have been doing it, my lord. I have been supplying to this Seats Corporation for many years, and this is, my lord, regarding the financial standing. And so far the experience is concerned, my lord, the experience has nothing to do with the, my lord, purpose sought to be achieved. Now, my lord, I am trying to draw parity from two other NITs issued on the same date and 3 dates thereafter, where these clauses are not there. May I draw your lordship's attention?
Just tell me one thing, this
Fine.
4.2.2, this black gram, say this 6, it is what? 642 lakhs.
Yes, my lord.
642 lakhs. This is 20% of the quantity to be supplied. The cost of 20% of the quantity to be supplied, correct?
Cost of 20% of the, my lord, quantity that, my lord.
Is going to be asked for,
Yes, fine.
going to be put to tender.
Yes.
So they are basically saying that whether you have the capacity to do this kind of job, show that you have done 20% of the.
True, my lord.
So what
But
is
then, my
wrong?
lord, so for that particular requirement is there because, my lord, they have to ensure that if I am given the contract, I am able to do it.
Correct.
My lord, for that, my lord, the other two tenders, my lord, issued on the same date and 3 days thereafter, this, your lordship will kindly see, my lord, what is the requirement there.
According to you, that no such requirement is there in the earlier
Yes.
tender.
There I
But
can participate.
There is always the first time.
My lord.
There is always the first
No, my
time.
lord, what happens, my lord, let me, my lord, show their modus
That
operandi.
doesn't mean that just because the tender document has been this way all the time,
Yes.
it should carry on till kingdom come that way.
No, my lord.
Can't
there is
they
a
put
design-
some
no,
new
there is a design
condition?
behind it, my lord. My lord, in the other two tenders, no experience is required because experience doesn't have anything to do, my lord.
Well, nowadays, in the earlier tenders, which you were doing as a lawyer, and 20 years back, hardly any experience was required. Now there's so many, there are restrictive tenders where experience is required, this is required, that is required.
No experience, my lord, for the purpose of what, my lord?
Actually,
I do not, I do not produce that because, my lord,
correct, but then you have got to have the capacity to handle that amount.
for that, my lord, the handling that amount, my lord, that is that has to be, my lord, taken care of so far as my financial standing is concerned, not the experience.
I don't, they are the authors, let us see.
My lord, I'll come to that, my lord. My submission, your lordship, is the design is like this, my lord. In the other two tenders, I can participate.
Ah.
And my lord, by some time, my lord, some years, I'll acquire some experience. Then, my lord, I come to their good book. Then, my lord, in the next tender, after 2-3 years, they
You
give.
don't come to their good book, you come to their recognition. You become recognized.
No, my lord, this is tailor-made so that, my lord, those.
That is what you're trying to show.
My lord.
They come to their good book so that you become one of their blue-eyed boys.
Then, my lord, then they.
It is possible, but that is not, how can we speculate?
My lord, that is, thereafter, my lord, I acquire for experience for a few years, then they put the condition that you require so much of experience. Now, what is this, what are they doing, my lord? What is the requirement? Requirement is that, my lord, I want to participate. I do not say that, give me the contract. I want to participate. You are restricting me from participating or by giving clause which are not necessary for the purpose sought to be achieved. I'd like to draw your lordship attention to the, my lord, other two NITs. At least one NIT your lordship will see at page 120. It starts.
So one is 4.22, and 4.21. You are unhappy with 4.21 also.
My lord,
4.2.1.
my submission, no, my lord, I am not happy because, my lord, both these
So
projects,
you want to set aside 4.2.1 also,
1 and 2 both.
and 4 and 2 also.
2 also. And my submission is that, my lord, 4.2.1 and 2, they, my lord, they are mutually exclusive. One cannot, my lord, be present in presence of the other.
Right.
Because, my lord, if I have the experience of, say, my lord, I am also a, my lord, builder, for instance. I may have, my lord, huge income from that. How can that be shown? My lord, that is what the 4.2.2 shows. That, my lord, that will come to save my financial standing. If that is so, my lord, then why do you require the experience?
No, this is so that you have experience and the capacity for that particular trade, not for any other
My
trade.
lord, for doing this trade, they have issued me a license. Very strict conditions, my lord. They have issued me a license.
Oh, okay. Then what about issues with regard to, say, there are many tenders issued. Say this is for seats, say for building contracts or for road contracts, where it is it restricts other people from entering unless they have a certain amount of experience or the financial capacity to a certain extent, to a certain amount, say 2 crores or 20 crores or 200 crores or whatever. Now, what about those conditions that are there in other spheres of business?
My lord, your lordship has to see in the particular facts of this case, my lord, why, my lord, if I have the financial standing, then why do you require the experience? If I have the experience, then, my lord, why do you have stringent condition regarding, my lord, the financial capability? And why, my lord, more so, when of the same date you issue another tender where these conditions are not there?
Okay, so according to you, one condition is enough.
One condition may be enough, my lord, that is also not required in view of the, my lord, fact that in the other two tenders, my lord, they do not impose this condition. Your lordship will kindly come to that, my lord, one condition
So
there.
Oil India doesn't issue the tenders which restricts others from entering.
My lord, that is, my lord, the arrow shot at me.
Direct arrow. Direct arrow.
Now, my lord,
Yes,
yesterday,
because here he's on the other side also in these cases. So I just wanted to know what his views were.
my lord, yesterday, my lord, this matter came up before court number 7, and while the matter was order was about to be passed, my lord, then the notice came from the registry that this is a bench full matter.
Ah.
So that is how the matter has come today. Yesterday, I made a submission while my friend was there. My lord, a fish cannot be judged by its capability to climb the tree. That is what, my lord, Albert Einstein said.
Okay.
This is what they are trying to do, because they are trying to oust the competition, and that is what is not required under the, my lord, some procurement rules.
That's your way of looking at it.
My lord, I am trying to convince your lordship. My
I
lord.
know. But then, you'll have to do a little bit more than that.
My lord, and that's why, my lord, your lordship will kindly bear with me for some time. Your lordship will kindly come to the another tender issued on the same date, my lord. That is at page 120 and relevant paragraph, page, my lord, 156. 156, your lordship will find the condition there. This eligibility condition.
No, just let me see 120.
No, my lord, that is a tender for hybrid seats.
They're different. They're different kind of thing.
No, I'll show my lord what is the difference. Those are seats, my lord. I do not produce seats. You allow the producers to participate. You allow the, my lord, dealers to participate. You allow the importers to participate. So I fall in one group, my lord, where I am a registered contractor. I am a dealer. And the difference between, my lord, hybrid seats and my lord, certified seats, my lord, they have explained. I'll show that, my lord. What is the difference? In effect, my lord, there is no difference because, my lord, it is produced by some growers, certified by, my lord, the central government agency or the state government agency, and I do not have any role to play there. Page 156, your lordship will find the, my lord, qualification criteria in the other NIT issued on the same date.
One 156.
156 one. 4.2,
Yes.
qualification criteria, 4.2.1, required minimum experience. Nothing has been specified. And, my lord, 4.2.2, financial standing, financial soundness certificate from bank. So my humble submission is that, my lord, this is enough to protect themselves from the, my lord, apprehension that at some point of time I may not be able to supply after I get the order. The same condition, my lord, in another tender issued 3 days thereafter, that your lordship will find at 207 and the relevant page is 242. Same conditions.
No, but you tell me.
Right.
Okay, out here they did not have the requirement. But what is wrong in a procuring authority taking a different view subsequently in another tender? What is wrong? Can't he add just because there was no conditions earlier? Does it mean that it has to continue till kingdom come like that?
If that, my lord, that condition is there in one tender, this ought to have been in the other 2 tenders.
No, I don't agree.
Your lordship will kindly come to the, my lord, the procurement rules. What does it say, my lord? Procurement rules have annexed that your lordship finds at, my lord, page 284.
Yes.
284, Government of Assam, orders by the government, the notification, these are the rules, and these are maybe called the Assam Public Procurement Rules 2020. Then your lordship may kindly come to page 287. Clause 12, 1, Roman 3. The last paragraph,
There will be a rule, it will not be clause, no?
a rule, madam, I'm sorry.
Rule 12.
Rule 12, 1, small Roman 3, the last paragraph. Madam.
Yes.
The clause 1, sorry, my lord, rule sub rule 1 starts with the procuring entity and all officers or the employees of the procuring entity, whether involved in the procurement process or otherwise, or other persons involved directly or indirectly in any way in a procurement process shall maintain an unimpeachable.
Unimpeachable.
So is, my lord. Then, my lord, sub 3, not use or include unnecessarily restrictive or tailored specifications, terms of reference, statement of work, limitation of terms and conditions that may discourage wide competition or unnecessarily exclude certain categories of prospective bidders from participation.
Is this the entire thing of this rules?
Rules, my lord, 284 to
The rules, is
complete.
this 2020 rules?
my lord. This is complete, my lord.
Assam Public Procurement Rules. What is the difference between the 2017 rule
2017 is the act, my lord, under which the rules are to be framed.
and this is the rules?
These are the rules.
And what does the act say regarding who will interpret whether any term in a tender is to be interpreted? Who is the authority? Huh?
If the document is mentioned in respect of interpretation, they can make a query. That's clear.
Let us see that.
But the document. Complete document.
I am intending to participate in the other two tenders, my lord. There is no.
No, that is all right. My query is with regard to this clause, these two clauses, who is the authority to decide in terms of the rules, whether it is restrictive or not, or not in consonance with the 2017 Act and rule? 38.
This 48 and 2.8 mentioned about verification of bidding.
A bidder requiring any clarification of the way shall communicate in writing to the corporation.
They have not approved.
No, in fact, my lord, there has been a pre-bid meeting. And in the pre-bid meeting, my lord, this.
No, that, but did you write any letter?
I did not, but then, my lord, there was pre-bid meeting. And there this question was raised and the, my lord, the bid committee has discussed it.
Where, let us see that.
My lord, that your lordship will find at page 118. 117 is the, my lord, minus of the departmental bid committee. One.
Yes,
117 is the, my lord, the minus. Well, minus of the departmental bid committee meeting held on 10/4/2024 in the conference hall. The managing director, some citizens pleased to place the queries received from bidders. Malad, in
Yes.
fact, I don't have any instruction whether in writing it was given or not, but the query was.
no, let
that
us
was-
see that issue was discussed.
Yes, my lord. That your lordship will find at, my lord, next page 118, serial number 3.
Yes,
Experience to be counted from any seat business instead of certified and truthfully labeled seats against the estimated quantity of schedule of items from the last 3 years. And the finding of the view of the bid committee is that no change. They will not make any change.
correct.
In case of certified seats, government notified certified agencies certify the seats of the growers registered with them after considering the technical aspect, norms, and through different processes. But for truthfully labeled seats, it should be labeled. It is labeled as truthfully not certified. Similarly, in case of hybrid seats, the process is also different. So it cannot be treated as similar items. My lord, there are two, one, there is a.
Now, what about that 4.2.2? That was
4.
never an issue.
4.2.2, my lord, yes, my lord, at the serial number 9, next page.
9.
Yes. No, in fact, serial number 7 also, annual turnover at page 118. Annual turnover of 10% of the quoted value of the quantity, that was the, my lord, request made. No change, a percentage of turnover is fixed in order to ensure smooth and timely delivery of seats. Estimated quantity of schedule of items is reduced. As a result, turnover is also required lesser, thereby addressing the query. The next piece,
So out here, they said that instead of 20%, it should be 10%.
that is what we, my lord, asked for.
You did not ask for anything. You asked for 0%. You only want bank account statement.
Bank
Ah.
directive.
So that was never, you never raised the issue with them.
My lord, there are other prospective, my lord,
So they had gone with regard to it should be 10%.
they have gone with the 10.
Yes, 10%. Now,
Even then, my lord,
now they were agreeable to 10%. So the authority said no. What is wrong now?
My lord, first thing, my lord, they have to, my lord, satisfy Roshi as to what is the difference between a certified seed and the, my lord, truthfully
No,
labeled.
no, with regard to, first of all, let us not digress with regard to turnover. With regard to turnover, there was no issue raised by anybody with regard to the fact that there should not be any turnover certification to be made by anybody. There was nothing like that. Only thing was that instead of 20%, it should be 10%.
Yes, my lord, that was the
So
point.
that issue now, according to me, now is, I mean,
No, even then, my lord, if
water
it is,
under the bridge.
even if it is 10%, my lord, then also I can participate in some items. My lord. There
No,
are
no,
many
but
items.
then that was not your.
No, my
okay.
case before lordship is that, my lord, the clause 4.2 and 4.1 they cannot coexist. And therefore, my lord, these two clauses are bad. These are restrictive. And my lord, this also violates the provision of the.
So this
the rules.
2.1 is with regard to serial number. 4.2.1 is with regard to.
That has been discussed at page 118, my lord.
Yes, yes. Which serial number?
Serial number, in fact, 1, 2, 3, all are there. I'm just, my lord, highlighting 3.
I think it is 1.
One is, my lord, minimum experience of to 10% against quoted value from last 5 years instead of estimated quantity against schedule item, no change. Minimum experience is sought as per clause 4.2.1 of standard bid document, where the minimum experience is required on supply of quantity, not of value. Estimated quantity of schedule of the items is reduced. As a result, minimum experience is also required lesser, thereby addressing the query. Therefore, my lord, my submission is threefold, my lord.
Just a minute, just 1 minute. There have been they have been asked to increase the annual turnover also. Not only that, to include 23, 24 also. It seems. I mean, a whole range of issues were discussed, it appears.
My lord, my submission on that point is this, my lord.
Yes,
As I have already
I'll
said,
just
my lord,
I'll just record your submission. Yes, number 1.
no, my lord, before that, my lord, I'll just answer to this query, my lord. Because, my lord, there are three classes of participants who are allowed to participate. One is the, my lord, producer. The other is the, my lord, the registered contractor and the, or dealer, rather. And the third is the exporter or importer.
Anyone is allowed.
And they are,
Anyone is allowed,
Yes.
provided you have that 4.2.1 or 4.2.2.
no, my lord, what I submit is that if you require the experience, this experience ought to have been for the, my lord, producers. I'm a transporter, man. I transport it, I get the order, I procure from the, my lord, producer.
No, it's only requires experience of supplying.
Yes, my lord.
It does not say that the experience of growing
That is not.
or experience of exporting. It just says experience of supplying. It can be import, export, anything.
Yes. So on that, my lord, that your lordship was about to note down. First submission is that, my lord, these conditions are restrictive. It has unnecessarily restrictive condition.
Conditions are restrictive.
Restrictive, and therefore it, my lord, the competition is more, and it has been
Competition has been lessened.
and it is tailor made for certain blue-eyed parties.
And tailor-made.
Secondly, my lord, this is not in conformity with the, my lord, the procurement rules.
Not in
Conformity with the Assam procurement rules, 2020. Which,
2020 rules.
my lord, 2020 rules.
That is page.
That, my lord, the relevant at, my lord, page 284.
Huh?
284, 287 is the relevant clause.
There.
This condition, thirdly, my lord, these conditions are not such to achieve the purpose for which the tender has been issued. In other two tenders, my lord, I can participate. There I have no difficulty. Why these conditions are imposed? Because it doesn't have, my lord, any nexus with the purpose of to be achieved. And one question may come, my lord, regarding the delay, because that was also raised yesterday. That, my lord, I have come late. Today is the last date for submission of tender. On that, my lord, my submission would be, the tender was issued on 8th of March 2024.
Issued on
8th of March
8 March
2024. The last date was given as 28th of March
2028.
28. Then, my lord, on 13th of March, a corrigendum was issued
13 March. Corrigendum.
at page 105. Then
Corrigendum regarding
that is addition of items, my lord.
page 130,
130. Page corrigendum 105.
105.
105. Some items were added, my lord.
Items added, but then that has nothing to do with the, this.
Then the second corrigendum was issued on 27th of March.
Yes,
And there, my lord, the last date was extended to 19/4/2024.
extended to 19/4.
19/4/2024. Then, my lord,
Page
that is at page 108.
08.
Then, my lord, on 16/4/2024, page 109, another corrigendum has been issued.
Third corrigendum.
Third corrigendum has been issued. Where, my lord,
Dated
that is, my lord, 16th of April, 16/4/2024 at page 109.
yes.
And in fact, my lord, that corrigendum is under challenge by another petition. Next item, my lord, my another Mr. Das, so we are going there. So, my lord,
Well, what
therefore,
does the third corrigendum say?
this corrigendum, my lord, the last date of submission was extended till today. And, my lord, regarding the experience and, my lord, annual turnover, my lord, there has been some change, by which, my lord, my learned friend is aggrieved. I am not aggrieved, my lord, but by that directly. But then, my lord, quantity was reduced.
Quantity reduced by this.
Yes,
third.
my lord.
So he's agreed with the quantity
Yes,
reduction.
yes.
He wants to supply more.
Perhaps. Therefore, my lord, there is no delay in the approaching this honorable court. And, my lord, they may speak of, my lord, some season, because they have to supply the seeds to the farmer at this stage, my lord. And this is the season. But then, my lord, the technicalities are such that, my lord, they cannot finalize it before at least 1 month, my lord. This statement I am making, my lord.
So that is a different issue.
But then, my lord, I am not late in coming to the court.
But the thing is, you did not file any representation to them.
My lord, whether that was filed or not, my lord, I don't have instruction, but from the, my lord, minutes of the bid committee.
Then how come you have the grievance? And you have come to this court.
My lord,
Why didn't you approach the the concerned authorities who had issued the thing.
My lord,
Okay.
this bid committee meeting discusses this point, my lord. Discusses this point. So
So you were aware.
that indicates that, my lord, it was maybe, my lord, that was submitted. So that clear instruction I did not, my lord, have whether anything was given in writing or not, I do not know. Therefore, my submission before Lordship is that, my lord,
Because the meeting minutes of the departmental bid committee was on 10th April.
yes, then.
And, that is also not under challenge.
No, my
And
lord,
you
I
knew
have-
about it. That's
No.
what you said. You
No, it
knew
is-
about it, but you did not add anything of your own there.
No, my lord, I have, my prayer is that, my lord, clause 4.2.1 and 2.2, along with all consequential actions, my lord, that is my prayer. That this is a
No,
consequence.
I agree. I agree.
Right.
But first of all, you did not make any representation to the concerned authority for considering your grievance.
My lord, I cannot.
At the time, when you knew that the DBC had sat on 10/4/2024.
My lord, I
That's
don't
what you have just said.
My lord, that, on that, my lord, I don't have clear instruction of that. I don't.
So you don't know, you didn't know that it sat.
Whether it was,
Huh?
whether it was given in writing or not, I do not know.
No. Did you know whether the DBC had sat or not?
Yes, my lord, my instruction is that they had, my lord, objected and they had, this was discussed in the, bid committee.
So you were aware that the DBC had sat on 10 April?
Yes, ma'am. But then, my lord, on this, your worship will, can you consider that, my lord, even if I do not, my lord, assuming that I have not approached, my lord, even then, my lord, this does not bar your worship from entertaining because I do not have any other remedy and that is not applicable.
Maybe,
Right.
but then if you knew that they sat, you had all the time in the world to write a letter to them.
My lord, my humble submission will be that will not bar, my lord, the petitioner from approaching your lordship, my lord, when that remedy, eventually, my lord, that remedy cannot be efficacious. On that, my lord, there is a case law, I'll place your lordship, my lord. That is, my lord, Bar Council of Delhi versus Surjit Singh, 1984 SCC 211,
1980
volume 4,
for SCC
SCC 211.
211. Para?
The relevant paragraph will be paragraph 18, my lord. Now, my lord, on the query, because this comes to the mind, my lord, always, that it is for the, my lord, the tendering authority to impose the conditions, whatever condition they feel fit. On that, my lord, there are many case laws. I'll rely on only one case law, my lord, Michigan rubber, one particular paragraph.
Only one.
Only
One particular paragraph.
Yes, fine. Copy has a need. I think, my lord, a copy has been already given to the court.
Given to whom?
In fact, the matter was heard at length yesterday, my lord, court number 7.
And
But then, my lord, the registry then corrected his mistake of listing it in bench number 5, bench 5. And therefore, my lord.
y'all y'all probably made a mistake in approaching that court. You should have mentioned it here.
Could be. So, my lord, the copy must be there, my lord. Page 229, paragraph 23. May I take your lordship indulgence to read it, my lord?
Yes.
From the above decisions, my lord, a lot of decisions have been discussed. The following principles emerge. A, the basic requirement of Article 14 is fairness in action by the state and non-arbitrariness in essence and substance is the heartbeat of fair play. These actions are amenable to the judicial review only to the extent that the state must act validly for a discernible reason and not whimsically for any ulterior purpose. If the state acts within the bounds of reasonableness, it would be legitimate to take into consideration the national priorities. The fixation of a value for the tender is entirely within the purview of the executive, and the courts hardly have any role to play in this process except for striking down such action of the executive as is proved to be arbitrary or unreasonable. If the government acts in conformity with certain healthy standards and norms, such as awarding of contracts by inviting tender, in those circumstances, the interference by the court is very limited. C. In the matter of formulating conditions of a tender document and awarding a contract, a greater latitude is required to be conceded to the state authorities unless the action of the tendering authority is found to be malicious and a misuse of its statutory power. Interference by courts is not warranted. D. Certain preconditions or qualifications for tender have to be laid down to ensure that the contractor has the capacity and the resources to successfully execute the work. And E. If the state or its instrumentalities are reasonably, fairly, and in public interest in awarding the contract, here again the interference by court is very restrictive, since no person can claim a fundamental right to carry on the business with the government. My submission before lordship is that, my lord, this particular conditions, they only, my lord, restrict my lord, participation, and it does not serve any other purpose. And my lord, so far as the financial standing is, my lord, concerned, that can be taken care of as in the, my lord, other two tenders. Therefore, my lord, they have to satisfy your lordship as to why, my lord, in three identical tenders, there are my lord, two different conditions. And my lord, I am not saying, my lord, that I am entitled to get the contract. My lord, there is another decision whether I burden your lordship with.
You can, I might dispose of the matter today.
Then, my lord, 2006, volume 11 SCC. This one, 2006, volume 11 SCC 548. BNS Joshi and Sons versus Nair Coal Services.
Para?
My lord, relevant paragraph will be paragraph 66,
Yes.
65 and 66. Paragraph 65 says, my lord, we are not oblivious of the expansive role of the superior courts in the judicial review. 66. We are also not shutting our eyes towards the new principles of judicial review which are being developed. But the law is, as it stands now, having regard to the principles laid down in aforementioned decisions, may be summarized as under. Number one, if there are essential conditions, the same must be added to. My submission is that, my lord, these are not essential conditions. If there is no power of general relaxation, ordinarily this
Is there an issue?
my lord.
Is there an issue here?
Yes, my lord, that is what I have raised before. Lord.
Yeah, your case is that this law should not be there at all. Whether it's ancillary or essential or that is not an issue at all.
My lord, my submission is this is not essential and therefore it should.
Okay, not an essential condition.
Therefore, it ought not to have been there. my
So
lord.
it should not be, it should, okay, sir. Not an essential condition.
To, my lord, achieve the purpose sought to be achieved.
To achieve the purpose of supply of seeds.
Yes, my lord. Then, my lord, I'll skip the others, my lord. Sub 5.
Yes.
Then, my lord, 65, Roman 5, my lord, I'll not read entire, my lord. Roman 5,
65 Roman 5?
Roman 5, my lord, next page, 572.
Acha, okay. Yes.
When a decision is taken by the appropriate authority, upon due consideration of the tender documents submitted by all the tenderers on their own merit, and if it is ultimately found that successful bidder has in fact substantially complied with the purport and object for which the essential conditions were laid down, the same.
Did you submit any tender?
My lord, I want to submit the tender, my lord. That is why I have come here, my lord. I don't say, my lord, give me the contract.
So this is not applicable to you, it appears.
My lord, unless, my lord, I submit my tender, my document, my lord, how can I be assessed?
Look, that is one, that's correct, but the problem is that you did not make any representation to the authorities that this should be changed, that you want to participate. Have you written any letter to the authority that you want to participate, but because of these restrictive clauses, I am not participating unless you change these clauses? Have you written some letter
I
to
am
the?
hesitating that before your lordship.
No, no, have you written to, I am not the authority. I am asking you a question. You have not done it.
My submission is that, my lord, that is not an efficacious remedy. my lord.
Okay.
Therefore, my lord, I'll implore that your lordship will, my lord, direct them to satisfy our lordship, what is the difference between these three tenders? Why I can participate in one, two, and I cannot participate in one?
Okay. What is the other tender, that the third tender, you have shown me only two. One is
Yes,
at
my lord,
page
third
26.
tender is, your lordship will find, at page 207. That is for hybrid vegetable seeds.
Third tender is at page
At page, my lord, 207,
dated
dated 11/3/2024,
11/3/24.
after 3 days of the present tender.
And the tender issued on 18/3/24. Okay.
8/3, my lord, 8/3.
183. That is the present case.
My lord, 8/3, there were two tenders.
Okay.
One is regarding this, my lord, which I am saying,
Certified seed and one by the hybrid seed.
hybrid seeds, and the third one is for, my lord, hybrid vegetable seeds. And conditions are, my lord, the same in the other two.
Okay. Then, yes. No, huh?
No, it's important, my lord, before my lord.
Why?
No,
I'm-
I'm one of the same.
No, his case is different.
Same tender. No,
No, did you submit any representation to the authorities?
my lord, that's I will give. I'm on a different footing. I'm not, I'm supporting the terms and condition of the NIT. It's not my case.
Okay.
Eligibility condition also, please, he might not, he'll get a term, because that's how your lordship, I was behind the back. I was listening that terms and conditions are open for you, is a prerogative of the employer. That's why we can't. We are supporting that terms and
Okay,
conditions.
okay.
Absolutely no problem. Annual turnover, financial, we are all supporting.
Ah.
We have no problem. But now, what is important in this case, if your lordship just allow, because this is very relevant. Because I have been watching this proceeding, my lord. My lord, my learned friend challenged 4.21 and 4.22.
Yes.
We are not challenging it.
Huh.
We are accepting it.
Yes.
We are saying absolutely there is no problem.
Correct.
It's a prerogative of the government.
No, yes.
It's a
Okay.
prerogative of government.
Correct.
1.22, financial soundness is required and experience also is required.
CPWD manual is there where restrictive tenders are allowed,
No
all those
problem.
others.
But the problem here, why we have approached this on court? We have not approached on the basis of the NIT which was quoted. NIT which was quoted.
But you
on-
have approached because of the corrigendum.
Why?
Third corrigendum.
Why, my lord? That's the answer. Why?
That's
If
the
you see-
question why, not the
Why?
answer.
Why? Sorry, my lord. That's why. If, my lord, when,
To be or not to be is the question.
yes, yes. My lord, this is on 8/3/2024,
Yes.
when the committee said, so they decided that this will be the annual action for a particular year. Annual action, the quantity. This will be the quantity they set together because they know what was the previous year their supply was made. So a scheme is there. There are a lot of 5 schemes are there.
So, look, we will not talk about the third corrigendum while we discuss this thing, because we cannot. I don't because I'm planning to dispose of the earlier case.
No,
Well, you're basically scared that you have an apprehension that this order will
No,
cover the
no,
third
that- no,
corrigendum.
no, no, it's not that.
Okay,
Not
then.
that. Please, my lord.
No,
I-
because you see, I want
No,
to
I have-
dispose it of.
no,
I
no,
can,
I
two
have
things in my
understood.
head will be
No, no,
problem.
that's true. But my lord,
If it's a Marwari businessman, four telephones, 4 different conversations he can have.
my lord.
Unfortunately, we don't have that
No, no,
capacity.
no, my lord will kindly see. Why?
That's
No,
what.
no,
That's
it's okay.
Yeah.
My lord, today, if your lordship, I don't know what's your lordship after decision of the court. We only as a lawyer we argue.
Yes, yes.
It's not the end of the day, every order will get it from the court. It's
Yes.
not that. It's your lordship will decide. But what I think my case, it's liquid, it requires a consideration by this honorable court. Why I will justify it? Why I'll justify it?
So let me dispose of the first one, the earlier one. At least
then
while
why not-
he's still there also.
No, I
Then I will hear you.
No, then I don't know how your lordship takes it. How your lordship takes it. Maybe your view of your lordship, that's me. I don't know how your lordship takes that.
Hmm.
Because the NIT is the same. NIT is same. 4.22 and 4.211. Your lordship will make a comment on that also, my lord.
Yes.
That's why a bit of your lordship will kindly, you will make, and I am supporting.
Okay. So you're supporting everything. Only thing the lessening of the quantity is challenged by you.
Now, if they have now, let us for an argument's sake that lessening also is being done.
Huh.
On what basis you have done the lessening?
So they've reduced the
They have-
amount that they want.
Why?
Huh.
They have reduced. Now your lordship has seen 4.22 and 4.21.
Yes.
That's average annual turnover. If the quantity is 19,000 in one particular item is black gram, 19,000. So the average annual turnover will go up. Only because those experience will come, so that the requirement to the farm, to the government, and in turn it given to the
No,
farmer.
by way of the corrigendum, the requirement, it will come down.
It
The
will come
percentage.
down.
Yes,
Now,
come down.
once it comes down, average annual turn also goes down. Average annual turn also will go down. So
Correct,
meaning
it will go down.
basically everyone,
Ah.
everything will go down.
Correct.
So why they have done it? Why not? Because the entire, the sanctity of the earlier tender of the NIT by few of the bidders who comes in a pre-bid meeting, 3-4 bidders makes a complaint saying we can't enter into it. Now, the judgment of Director Educom has been reversed by them, saying that the best person should come. Now, I think I was hearing, I didn't get the opportunity of arguing for this court because this matter came up, then it was referred before that court. And there was some objection raised by the registry saying this is a matter of bench court. I was not heard in that. And my learned friend, one query was that.
No, it appears that yesterday a mention was made before a
Yeah.
court which does not
Did not have.
does not handling bench
Well,
form.
I didn't.
So it was listed by before the court. So now they've corrected the
Now
mistake and they've
corrected
come
and it
in.
just come before. Now, my lord will kindly see the corrigendum. Your lordship has known. My learned friend has argued this matter. Your lordship knows what is 4.22, what is 4.21. So I am absolutely with the government. There is absolutely no problem. And earlier in 2021, the requirement of the government, my lord, will release a scheme to the farmers. My lord, why I am telling it, there is a reason. No, there is a reason. You cannot slash down from 19,000 in an NIT annual action plan a second, and in 16.4, some pre-bid meeting, 3-4 bidders comes and you change it to 5,000. And the requirement of the government on papers, I'll show it, in one of the scheme is more than 5,000. How you have done it?
Whether this court can go into those issues
No,
with
no,
the
I'm
administrative decision.
No, I'm saying it. No, I'll show one.
There's no contract
No.
agreement between you and the
No,
government.
that's I'm not saying contract. The decision which has been taken by the government is totally arbitrary. This is what I'll show it. And there is judgment of the Supreme Court, I'll show it. But let me place the facts, my lord. Judgment
Let
will
me
come
see the
later.
corrigendum number 3.
Now, see, let the corrigendum.
Which case is this?
Yeah.
Your case is item 16.
2325. My lord, your lordship will please see the corrigendum. First see the NIT PC 74.
Page 74.
PC 74. See page 74, my lord. This is the original requirement.
Yes.
Details of requirement. Lordship got it. Now, number 1 is black gram. Let us be one class of seeds. Quantity is 19,000. Lordship will kindly note down 19,000. So all these
This is as per the original requirement.
yes, original requirement. This is original requirement.
Financial standing is connected.
So bid security and financial standing is
Connected to this one.
connected to this quantity, which your lordship will find Page 64, 54, kindly see. Kindly see 54, 2.20, 2.201. The bidder see 2.20.1. The bidder shall furnish as part of its bid a bid security in the amount as specified in a BDS in favor of Assam Steel Corporation Limited, Guwahati. So if you see at page 67,
PDS means bid.
bid, it is defined in page 67. 67, kindly see. Yes, many of that will be here.
No, what is BDS?
I'll
What is-
just show it, my lord. I'll show it, my lord. See 67 page for a moment. 67. Kindly see ITB 2.20.1.
Yes,
So bid security will be as follows. Let us take
BDS means bid security.
bid security. Now one is the black gram. So the general category, kindly see at page 67,
Yes,
general category of at page 67.
yes,
See one black gram, that is 19 lakhs, I think, 26,600. Average annual turnover. This is a turnover. Suppose you supply that 19,000 for a general candidate, average annual turnover, this is what he has to supply, bid security. So, but for the scheduled cost, this is less. So, all this quantity, each of the items, average annual turnover has to be paid. This is what it says about the bid security. So, see page 72.
yes.
4.2.2. Financial standing. The bidder shall have at least an average annual turnover of rupees as mentioned table below. 20% of quantity for scheduled item. That is again each crop during the last 3 financial year ending on 31st March 2000 from any business. So black gram, my lord, annual average turnover, they have shown this green gram. So it's so on, it goes on 27. So your lordship, this is, if your lordship see, this is connected to 5.1. Connected to 5.1. It is connected because it's a financial standing.
What is 5.1?
5.1 quantities. 74. If you see the quantity, one is black gram is 19,000 quintal.
Correct.
So if you see at 72,
Yes,
72 black gram, average annual turnover should be this amount.
correct. So,
6 crores so and so. So it is black gram 19,000. One particular bidder should have 6 crores so and so.
annual turnover.
And so we have no problem, absolutely no problem on all this.
So,
4.22.
and you have got to show only 20%.
Yes, this is absolutely, we have no problem.
20% of the annual turnover.
Yes, we no
Ah,
problem.
then-
This is absolutely, maybe they have done it, my lord, keeping in view, experience will come into it and they will
Okay, now
supply.
let us see the
recurrent.
corrigendum, I think.
Now, 118. This is the corrigendum. See at serial number 119, corrigendum number 16/4/2024. See at 6.
This is the third corrigendum.
Third
16.
corrigendum. See ITB 2.20.1. Bid security. What you got it?
ITB 2
Uh,
point.
2.20.1. Your lordship will kindly note down. In originally, there your lordship note down, it was a page 67, the bid security. This 2.20, they have changed it. That's why I'm saying. Kindly see, black gram, the average annual turnover as your lordship has 6 crores, they have now reduced to 5,63,987.
Bid security.
The bid security they have reduced. Why? Why? Because the amount of black gram has been reduced.
Correct, sir.
So now the question is same at serial number 7.
So it's
At
only,
120.
your only grievance is with black dam.
No, all the items has been reduced. So if you see 4.2.1 at page 120, that also has been changed. At 122, 4.22 has also been changed. Kindly see, my lord. 4.22 has also been changed. Annual turnover has been reduced. And also at page 123, at 9, section 5, 5.1, quantity, kindly see it has been reduced at page 123 for all the items. See at 9,
Requirement.
black gram is 5562. Originally, it was your lordship, kindly note down. It
So
was 90,000.
basically, you're agreed with the lessening or the reduction in the items required.
Now whether I point out before the court and court will not accept like this. How you are, 55 is a government requirement.
Correct.
How you are agreed by that.
Correct.
If they want less, it is up to them only. So I have to justify it.
Correct.
Whether it is properly they have reduced. If they have reduced, absolutely no problem. In what manner they have reduced? Now, there are
No,
requirements.
first question. Did you submit any representation
For
to the
that-
authorities?
16.4.
So you
Consequence.
did not submit.
No, this is a,
Did you submit your tender?
no, but the tender last date is today. Today at 5 o'clock is the last date.
So you did not submit.
Today is the last date, madam. Yesterday we have,
Today is the last date.
yes, last date, yesterday we moved this matter, madam. Somehow it spilled over, it has come because the appropriate bench. Now, if you lordship kindly see the amendment on 10/4/2024, there was a minutes of meeting which they said at page 126. Kindly see 126, which my learned friend has pointed out. See at page 126. The names of department bid committee meeting held on 10/4 in the conference hall. Kindly see the first point. The DBC approved the estimate quantity assessed on the basis of the annual action plan 2024-25.
Page?
Page 126.
Yes.
See, that is 10/4. That means my pre-bid meeting, some bidders came. The bidders came, 2-3 bidders came before them, and they have taken some decision. One, kindly see my
Yes.
DBC approved the estimate quantity assessed on the basis of the annual action plan 2024-25 with additional margin of 25% to meet up any existence requirement. So when you set annual action plan was 19,000, my lord, kindly see the justification which I am making it. 8/3/2024, you have made it, a requirement was 19,000. Few bidders who want to enter into it, and for that purpose, you are saying, no, we are changing it. Then annual action plan, we are changing, but we are keeping additional margin of 25%. End of the day, you are making all the entry to this competition. My lord, now the query came, which was how many bidders were last time? With 20,000, my lord, the quantity, 20,000. 26 bidders participated, 19 was technically qualified. And now your lordship, I'll give you an answer.
20, just a minute, 20 bidders.
26 bidders,
Okay, last
last
time.
26.
And now, okay. So
Now
we don't.
will be 200.
13 to
Para 13, kindly see for your convenience, para 13. At page 13, kindly see that, my lord. Then I will show the requirement of the government. See, para 13, page 13. Para 13. See page 13, para 13.
We've got a full bench. now. Yes,
The petitioner respectively is a requirement of the certified, one paragraph. Seats has been fixed and published by authority originally on the basis of actual requirement, same can be compared from the quantity procured last tender process issued in 2021-22. But after incident, subsequently, by the impugned corrigendum dated, required quantity has been reduced subsequently without any basis, only with an intention to favor waterway. Now see, black gram, 20,000, procurement point, because what happens, my lord? It spills over for next 2 years. The seeds are supplied by the government, it grows, the seed grows, the remains of 5,000 doesn't remain. Then there is an increase. There is increase. Kindly see 24937 for the year 2022-23, 2023-24 is 6,300. Now 19,000 was the original NIT. They slashed down to 5562. Now all the items. Now I'll justify why they could not have reduced. That's the answer, my lord. I'll give an answer. 130.
no, now it has been reduced to 5562. At
333. Kindly see why.
333.
333. Kindly see.
Yes.
333. This is the requirement of a particular of a scheme under the, kindly see at page 333, my lord. This is on 18.4. District Agriculture Officer, district-wise breakup of different inputs under food nutrition security. There are 5 schemes. If you see 336 onwards, 336 onwards.
Maybe they want to do it in phases. How do we know?
No, not, my lord, with a margin of 25%. Others don't give the 25%. Phases wise, no, my lord, what happens, you kindly see the requirement, that's why I'm justifying it. Your lordship will definitely, that's a government prerogative, 545, they can do it. But when a requirement was asked for from each of the district, it goes beyond that amount, that quantity. See, my lord, 338, kindly see, 338. For one scheme, kindly see 338. For one scheme. Kindly see black gram. One scheme, my lord. Kindly see black gram.
Page?
Page 338. 338.
Yes.
338. This is district-wide breakup. So and so food and nutrition security. There is one scheme. Kindly see black gram.
Yes.
If you go down below, total is 3,000. Green gram 1,000. You see the chart which
Yes.
is given
Yes.
by the Director of Agriculture. So if you see down below 3,000, is only under one scheme. Now 340, there is another scheme. Kindly see 340. Another, see, see 340. Page 340. See the scheme. TRFA pulses. See, my lord, the scheme at 340. 340.
Yes.
This is scheme is TRFA pulses scheme. Lordship got it?
Hmm.
Yeah. Now, if you see the serial black gram, summer black gram 3,000. See down below, my lord. My lord, 6,000 in these two, there are 5 schemes. And today, by corrigendum, you reduce to 5,000. Where is the nexus of the original NIT which you have flowed? Now the question here is,
I don't know if I can go into this. You have to show me how I can go into this.
now I will show it how your lordship can look into it. See, my lord, to what manner the court can look into it.
Show me the citation.
Where this, I will show a judgment, 2002 2 SCC 188. Correct, no?
2002.
2002 2 SCC 188.
Yes. Para.
Para 25. See para 25. see to next page, your lordship is holding this 2002 SCC.
Yes, yes.
Now, please turn 25, my lord, you skip this. See the expression arbitrary on the top, first line, 25 on the first was not reasonably many. The expression, lordship, what is the expression? Page 25, para 25, it has been pleaded, 1, 2 is, please give the what is arbitrariness.
Yes,
Now, if your lordship turn, expression, see the expression
yes.
arbitrarily means in an unreasonable manner, as fixed or done capriciously, or at a pleasure, without adequate determining principle.
What right of yours is violated just because it has been reduced?
My right is violated on the requirement that is owned by the government, that it is more than the requirement what they are seeking for. You cannot, my lord,
What right of yours has
You
been
can-
violated?
then what is the right that you have prorogated tender saying the
You
19,000?
see, this
How
is,
you reduce it?
this is only an offer.
No.
No, right of yours has been violated. You have been
See-
asked to make an offer.
But my lord, my submission will be the arbitrary action of the government by issuing this corrigendum. No, you have taken a policy decision, my lord. This policy decision by the government by reducing is an arbitrary. Completely is an arbitrary, my lord. Tomorrow they will say 2,000. But requirement, no, my lord.
Prior to
No, that's
prior to opening a tender, they can do it.
no, my lord, they can do it. I am not saying they cannot do it. But my lord, the requirement has to be looked into it.
That is not your job.
My
That's the
job,
government job. If you don't want to participate, you don't have to participate. You don't have a fundamental right to participate in any tender process if you don't want to participate.
then what is the point of that? Why this has been done? Your lordship will definitely why they have done it. No, the original tender, the sensitivity of the tender goes. You can change it
no,
whatever you want to do it.
You see, the level playing field has not been changed.
No, it changed. Level playing field has been changed, my lord, I am saying. With great respect, I am saying it has been changed. Because the level playing field, what was originality, you have made a U-turn. You made a U. These are all food scheme, my lord. These are specialized.
Most probably, what you are saying is correct. That they maybe to favor some blood, but how do you prove it?
So this is why I'm giving an example to your lordship by showing it.
The only
chart.
thing, the only thing it'll be just an academic interest. They will give some justification.
No, let them give
110%.
My lord, I will accept. My lord, let them give a justification.
No,
We'll give a reply to it.
no.
Their justification has to be there. My lord, they can't say.
You have to first show this court.
I am showing it.
What right of yours has been violated? What fundamental right of yours?
That's what I am showing, my lord.
This is a commercial transaction. Where is the right? They have reduced the amount that they want. It is not that the tender has been opened also.
No, I am not saying.
Oh, you have not
tender
even
has
submitted. You have not even submitted it
How can I-
also.
My lord, my lord, your lordship is
If
asking
you
one
have submitted
question.
your tender,
Why your lordship is asking one question to my learned friend and me also. Where is the representation in your file?
yes.
But my lord, as what experience, my lord, I don't know, my lord, subject. Each and every case, representation is not required. With great respect, I'm just, my lord, with great respect, I am saying, my lord, each and every case, representation is not required in case of a tender.
Correct.
In
Maybe,
every case, I'm
maybe.
saying, yes, representation is required. But I think this type of cases, my lord, there are cases which are directly being challenged. It is something else, my lord, your lordship may accept, your lordship may not accept. That's a different views, my lord. That's a views.
Correct.
My views is that, my lord.
Look, everyone has got different views.
Yes, right.
Even
that's
the
why I'm saying.
apex court gives conflicting
That's
judgments.
That's what.
So who are we?
No,
Right
that's why.
down at the bottom of the
No,
ladder
no, that's
to
why.
have to be,
That's why I'm saying
all correct
tomorrow,
view. There's no
your
correct.
lordship is right.
My judgment or my order can always be put to challenge.
No. What I'm saying, that's a different. Your lordship is right. Today, some judgment will come. Tomorrow, that will be changed. With all great respect.
Correct.
One judgment.
What I
we'll
think
see,
is a very good judgment might turn out
we'll
to be a
show
very
it-
bad judgment.
We'll show it before the court. Court say, no, there is another judgment which is coming. What I am saying that we are not against the NIT. We are fully agreeing with the NI. There is no.
Agreed, but then you don't want to enlarge the competitive playing field because it has
Yeah.
been made to accommodate the blue-eyed
What are,
wolves.
no, my lord, what are
That's your
those,
case.
then what are those judgment of the Supreme Court, right from Silaki Bidarthi to Mahabir Otro to like Michigan, what my learned friend has shown, to last Mahabinda Express, all the judgments are diluted by going back to the old, my lord, that Educom judgment. Educom judgment, what it says, my lord, your lordship, remember their judgment. Educom judgment says there were small, my lord, they were the bidders who challenging a particular on NIT with the average annual turnover high. Now they come and they say we'll be out of the because these are small bidders. Court says nothing doing. We want the best experienced person to come. We want that they should deliver on time. This hard disk should be delivered on time. So you don't complain on this. No, small bidders. Whoever is their scope. Today, what you are reversing it. This scheme, the very basis of this scheme is that you give on time requirement. This is a basic requirement. Now, 5,000 you reduce, there is nothing.
So how much? So as per if the amount of that black gram, whatever, has been reduced to 19,000,
5,000.
5,000, how much will be the this
Average annual turnover.
is that 4.22? How much you'll have to?
20% of the 5,000 something.
How much will that be? Huh?
No.
So Mr.
It's somewhere, 1.5 crores.
So Mr.
It was
M.K. Chowdhury's amount to be deposited also will become less.
Everything will be less. All experience, finance. Idea is end of the day, idea is the credibility. Idea is the end of the day is the credibility of the particular. These are essential products, my lord. Now, one judgment, last judgment. One judgment. This is not yes. Educom judgment, but it is no. It has been cited. My lord will kindly take down note of one judgment. 2010 6 SCC page 303.
2010
6 SCC page 303.
303, yes.
64 kindly be seen.
Yes.
Kindly see 64. Kindly see. Nine.
You have not given us.
I have given book. You just see this, my lord.
No, what does it say? Please read.
I'll just read. It is true that the state or a tendering authority is bound to give effect to essential conditions of eligibility stated in a tender document. And it is not. I'm sorry, my lord. This is para 45. I'll just note down para 45.
Not 64.
No, sorry. 40.
64 is against you.
Principle of Educom and Tata Cellular manner has been.
Huh?
I will read it, my lord. I am my age. If goes against also, I can put against.
Correct.
I will always put against also. And I give an answer to it, my lord. See 45.
Yes.
45. I'll read 64 also, my lord. No problem.
Please read. Please.
Yes. See 45. In the Director of Education, so and so, the principal of Tata Cellular, so and so, though it has been discussed, my lord. It has been clearly held in the decision that in terms of the invitation to tender are not open to judicial scrutiny. Terms of the tenders, the same being in the realm of contract. The government must have a free hand in setting the terms of tender. Absolutely no problem. It must have reasonable play in its joints as a necessary concomitant for an administrative body in an administrative sphere. The courts would interfere with the administrative policy decision only if it is arbitrary, discriminatory, malafide, or acquitted by bias. This is my case. Your lordship will kindly note down. This is my case. It is
Okay.
entitled, this is my case. It is entitled to pragmatic adjustment which will be called for by particular circumstances. Court cannot strike down the terms of the tender prescribed by the government because it feels some other term of the tender would have been fair, wiser, or logical. The courts can interfere only if the policy decision is arbitrary, discriminatory, or malafide. So the policy decision where we have taken in the NIT originally only for few bidders, 2-3 bidders, you have changed it. Enter the
This was
concept.
after the tenders were open.
I'm sorry,
This was after the bids were open.
where in this
In that
case.
case,
And Educom, yes, where it went to the Supreme Court, my lord, that's a different. Now I just 64, let me put 64 also, my lord. It is true, the state or its tendering authority is bound to give effect to essential condition of eligibility stated in a tender document is not entitled to waive such condition. But that does not take away its admissibility to cancel the entire tender process. In public interest provided, such action is not equated with ulterior motive or is otherwise not vitiated by any vice or arbitrariness or is an irrationality or in violation of some statutory provision. It is always open to state to give effect of new policies used to pursue, keeping in view overriding public interest subject to principle where there is reasonableness. So this is my submission, my lord.
okay, I think we can hear you.
My submission would be very difficult manner. Let me first address to this also first point is very important, which otherwise the center point of this is why we have put this
Why we have?
two conditions.
Yes.
Justification.
Yes, yes.
It is a second position of the party is prerogative to.
My lord, I'm sorry, my lord. Can I take your lordship leave?
True.
My lord, somebody will be there.
So the party has followed the prerogative to put the condition Arbitrariness, followed by arbitrariness. Then
This is with regard to which one?
yes, sir.
Who has given me this?
Right part.
With regard to which case? Both.
Yes, both. Now, let's say, but there is a case where we are dealing with the supply.
But these pages that you have mentioned here is with regard to which writ petition?
But both covered.
How can it be page 37? But the page 30.
First case. Now. Let's say, there is a case we are dealing with, the supply of seeds to the farm. Now, let's know that the Kharif and Rabi seasons are the two seasons out of which we have to supply the seeds to the farmer within time.
Go to the issue why you have put that two clause. That's all.
Now, the first thing is, there is a standard procedure laid down by the our government of Assam, given the flag transfer. We are bound to follow my. Can I see my justification? First justification middle part, the finance department Dr. Assam has published a standard bid document in line with Assam procurement in 2017. 4.2 qualification criteria, 4.2.1 is required minimum experience. Now, suppose we must work of this out. Then what will be the consequences? We will go against the standard procedure laid down by the government of Assam itself. That we cannot do that. That flag, two flags,
You see, one of the issues that you have said has published a standard bid document. If it's a standard bid document, how can you have two different clauses?
Okay, but in respect to first case, now here is a case where the first case where would be put to condition which experience was standard. Now, so far experience.
And in the other tender, there is no such clause.
Exactly. But in West, that the criteria nature is just totally different. It is the hybrid manual tender that we have provided, and so far this tender is concerned with now we're dealing with. It is certified for
Certified seed.
particular conditions are there. In first condition, on single item, hybrid. There is 33 item we're dealing with. And the first matter that dealt with only the company who has already produced
And my lord, they will take to.
You see, the finance department, has it made two different standard forms of bidding documents? Has it made?
It's absolutely not the.
Then-
The condition must be there. In earlier also we put the condition.
Look, it's very easy to say, where is the finance department bidding document? Look, don't just say things off the hook. You see, when you say that they have made a standard bidding document, now straight away, there are two different documents. Because for one, you don't have that, those two, 4.2.1 and 4.2.2 is not there. But in the other you have, and both have been issued on the same date. Now, if there are two different clauses which are not there in the other bidding document, it shows that it is not a standard bidding document that was made. Now, who has made that? Which one is the standard bidding document?
In earlier four document, we have put the both conditions which is directed by the finance department standard way. Only thing difference is that in that two standard document, we have not put the condition of 20%.
Why?
Here we put only the 20%.
If it is a standard bidding document,
That
can you say, I have done this because it is as per the standard bidding document, but this I have not done it just because I want that it should not be
there
there.
is a difference.
Can you say that?
There is a difference. What I have given the entire judgment, even notice plan every notice may I read out. But here we have given the justification notice penalty for one by one.
Where?
My lord, my notice,
Where?
yes, yes. First justification my lord, about finance department. Now second point, my lord. Here, my lord, similar business means the business downside. Also, certified sheets are produced through a system under supervision of GOV affiliated certificate for the state of Assam organic seed certificate certification. For producing.
You're just repeating what is there. It is a repetition. The reasons for the same is not being given. Just what is the reason?
Take it back to next page. I have given entire justification. There are two classification of procurement.
Anyway, those are.
Now, floating plan is the first part of 35 and floating plan is a hybrid system. I have given the second part of floating plan. What is it? And is available.
Yeah.
Hybrid seeds, the hybrid seeds are kind of property right item. This is not the classification which pertain to 35. Because here, one of the farmers, they will tie up with, there is a procedure foundation first, three stage will across their entire thing will look after the certificate agency. Then my lord, it will get ready for my lord, supply. Hybrid says that hybrids are the kind of property right item. If a particular company agency develops one particular variety of hybrid seed follows law, it becomes an exclusive item of the company. Other can take authorization from state company and do marketing. So taking experience from a person bidder who wants to do the marketing of a RMC product does not.
This is not the issue at all. This is what do you mean? What do you mean exactly? This is not the issue at all. The issue is, why is the requirement of having experience in supply needed? That is the issue. You are talking about company having proprietary rights. That's got nothing to do with the issue at hand.
If person is not doesn't have any experience.
Mr. Counsel, I'll pass the order, whatever. Your note is making no sense. I'm sorry to say. At least I couldn't get it. Right.
I have given the entire that notice the justification in the respect of the both parts. Hybrid seed as much as hybrid certified.
That is not the issue.
And notice let them participate minority then exams they will look after minority. Suppose today is the last day, they can participate minority. If suppose their condition will not be followed, what is no matter? It is not minority. It is not a case that cannot be dealt with afterwards. But my lord, can you see that the only one thing is very important? The supply of services will start from 10 to my lord.
No, I'm not on that. I'm not saying the process.
Farmers interest is my lord bigger here.
I'm not saying the process. In fact, anything else to say? I'm disposing of this.
Well, my submission is only to one aspect. That so far 20% is concerned in respect of 35C. 35C.
20% condition that we have put for experience as much as for financial part. That is also the condition in respect of other two big where only 20% is not there. Only that is distinction that we have made.
I'm not getting you. I'm not trying.
So-
You see, the issue is this. He's saying, why should this clause be there?
Fine.
That's all. Now, that is what you have got to say, not about whether it is hybrid, it is a proprietary issue. Why is the clause there? Why is this turnover required? Why is this experience in supply required? That's all. That's what he wants to know.
Say that one.
Yes.
Make it smooth supply in time.
Ah, say that. That is what is required, not this
That is
note.
the financial stability that we have to test, madam. So that they should not fail to make the regulation. That is the
That's all. Good. Right. Heard Mr. M.K. Chowdhury, the learned senior counsel for the petition, assisted by Mr.
I'm sure.
M. Sharma. The grievance of the petitioner is with regard to. Which one is this? Your case is 2325.
2309.
Oh.
230.
Is with regard to. The with regard to clause number 4.21 and 4.22 of the NIT dated 8/3/2024. Wherein tenderers are to give their experience in supplying the certified seeds and truthfully labeled seeds besides their annual turnover for the year 2024-25. The petitioner's counsel submit that there is no justification for requiring tenderers to have experience in supplying the above mentioned seeds in terms of the NIT. No, they do not need to have the experience of supplying the above mentioned seeds. No, experience of supplying 20% of the estimate quantity of the seeds required to be supplied. Besides requiring the bidder to have the average annual turnover of 20% of the quantity of the schedule of items to be supplied for the last for the last three financial years ending 31/3/2023. Comma. As the said conditions are restrictive in nature. By putting the restrictive conditions, comma, competition for the supply of seeds has been lessened and has in fact been made has in fact been tailor-made for blue-eyed boys who are going to be favored by the state respondent. The learned senior counsel for the petitioners, for the petitioner further submit that clause 4.2.1 and 4.2.2 of the NIT is in violation of the Assam Public Procurement Act 2017 and the Assam Public Procurement Rules 2020. As the said clauses are unnecessarily restrictive and tailor-made for some and tailor-made to discourage wide competition by excluding certain categories of prospective bidders from participation. He submits that the impugned conditions do not have any nexus with the purpose to be achieved by the supply of seats in terms of the NIT. Next paragraph. The learned senior counsel for the petitioner submits that the petitioner has the experience. Is it? Do you have the experience of supply?
I have some experience, but not for 5 years.
Okay.
That means I don't
Has the experience
have some experience.
of supply of seats to the government and its instrumentalities. However, the experience for in the supply is not for 5 years. And you have got the financial capacity.
My lord, financial capacity not to that extent, fine. The 20%.
He also submits that he does not have the financial capacity in terms of clause 4.2.2
To
of
participate
the
in
NIT.
my,
Huh?
to participate in my lord
For-
several items. Maybe he will be able to participate in 2-3 items.
For several items, for several of the items mentioned in the NIT. Next. No, carry on. He submits that the impugned clauses are not essential conditions which would achieve the purpose of supply of seats in terms of the NIT. And as such, the impugn clauses should be set aside. He also submits that there are two other similar tenders issued by the corporation state respondent which were issued on 8/3/24. No, we issued on same date. One is same date.
8/3 to 24 and 11/3/24.
8/3/24 and 11/3/24, which do not contain the above two impugn clauses. So as such, there is no justification for including the two impugn clauses in the present NIT, which is under consideration of the. Next para, the petitioner's counsel also submit that the departmental bid committee held a meeting on 10/4/2024 with regard to various grievances submitted to the authorities with regard to the present NIT. Though the petitioner was aware of the meeting of the DBC on 10/4/2024. The petitioner did not submit any representation to the respondents for consideration at the meeting of the DBC on 10/4/2024. So what have you got to say with regard to this DBC meeting?
My lord, after the DBC meeting, my lord, they had issued the corrigendum on 16/4.
The third corrigendum.
Yes, my lord. Then, my lord, I have approached this.
Huh?
Then only, my lord, we have approached this on now.
What about that?
No change. My lord, in the, my lord, the DBC, my lord, there has not been any change, my lord. All the have kept as entity.
Gustav. After the DBC meeting was held on 10/4/2024, wherein a few changes, wherein one or two changes were made. Is it?
Yes, my lord, regarding that quantity.
Wherein a change was made with regard to the quantity of seats to be supplied in terms of the NIT. No change with regard to the other conditions of the NIT was made.
Which is reflected in the corrigendum dated 16/4.
Which is reflected in the corrigendum, third corrigendum,
Dated 16.
dated 16/4/24, issued by the respondent authority. He submits that as the No, that's understandable. Wait, wait, he submits that. Next paragraph, right? In support of his submissions, he has relied upon the judgments of the Supreme Court in the case of 1984 SCC 211, 2012 8 SCC 216, and 2006 11 SCC 548. Next para. Mr. S. Chamaria, learned counsel for the Agriculture Department for the Assam Seed Corporation. And who else? And okay, Mr. B. Chowdhury. B. Chowdhury. Don't say anything for now. This is just like Mr. S. Chamaria for the Assam Seed Corporation submits that the insertion of the two impugned clauses in the NIT is to ensure that the bidder can smoothly perform the supply work that is required and has the financial capacity to do so. That's all. Which is to be done within a specific time period. He also submits that the terms of a tender can be changed if required by the author of the tender, and the requirements of a procuring authority cannot be subject to judicial review. When first of all, accordingly submits that he accordingly submits that no case for setting aside the impugned clauses has been made out by the petition. Mr. B. Chowdhury, appearing for the response number 1 and 2, submits that he has got what? He also same. Okay. Submits that he has got no comments to make at this juncture. I have heard the runner for the party. Clause 4.2.1 and 4.2.2 of the NIT states as of the NIT dated 8/3/2024. Is it?
Mine.
8/3/2024.
Page 26.
For procurement of fresh certified seeds of different crop varieties for the year 2024-25 states as follows. Page 63 and 64. As is apparent, this para, as is apparent from clause 4.2.1 and 4.2.2 of the NIT. The bidder has to have experience of supplying at least 20% of the estimated quantity of the seeds for the year 2019-20 to 23-24. Full stop. Further, the bidders have to have at least an average annual turnover of 20% of the quantity of the items to be supplied during the financial years, during the last 3 financial years, that is 2021 dash, no, 2020 dash 21, 2021 dash 22, and 2022 dash 23. Before going into the question of whether, before going into the question of the validity of the of clause 4.2.1 and 4.2.2, it would be worthwhile to note that the state respondents had issued a corrigendum, third corrigendum on the NIT, third corrigendum dated 16/4/24 on the NIT.
That is just page 109.
Wherein it has the reduction part.
One one eight, my lord.
Wherein, no, this is the, no, this is 100 is different. Wherein it has the reduction of the items to be supplied. It is there, no?
Yes.
Wherein it has reduced the quantity of seeds to be procured by the seed corporation, Assam Seed Corporation. Respondent number 3 and 4. Thus, from the in terms of the third corrigendum dated 16/4/2023, the experience for supply of 20% of the seeds to be supplied would become less, and consequently, the 20% of the annual turnover required of a bidder would also become less. Go, sir. Next. The first question, as stated earlier, the question to be decided is whether clause 4.2.1 and 4.2.2 are liable to be satisfied. What to do? No time. At 2 o'clock, I've got full bench. If time permits. Okay. If time permits, maybe we'll sit again. Let me see what I can do now. I'll try to finish this order today. Both the cases, let's see.
There may be time after full bench, my lord. After-
Maybe time.
There may be time.
Depending, if we complete, then that is also going to be another. Then my job will again, our job will again start. If we complete that.
Yeah.
My lord, the best way will be a notice to be issued and eliminate some protection and lordship will hear it. Because your lordship anyhow, your lordship will not, this is a division. I said there is a bench.
Huh?
There is a bench which your lordship is sitting.
Yes, yes,
I think full bench.
yes.
So a short date notice, in the
So
meantime,
he also said, my lord, that we can participate. That is the submission.
No, you can participate.
no, only what will is that your lordship will keep it open. In the meantime, what will happen? They will not proceed, but in the meantime, let it proceed, participate. They will not proceed. In the meantime, will.
No. They will proceed.
No, I am just telling your lordship, if that's what, then,
Only thing at best I can do is I can issue notice only,
no,
nothing.
no, then what happens, my lord? Then what happens, my lord, if this notice is okay? My lord, notice absolutely, my lord. What I am saying that if this, they will not, but they will take some time. In the meantime, your lordship will fix it.
No, I'm trying to dispose of.
No, that's fine. If your lordship, I'm saying that you're also sitting in a, the full bench, full bench.
Already made a comment that the final disposal, we can to final disposal.
No, finally dispose of the number one, so is sure.
Yes.
Number two, I don't know if I'll have time.
Because last date, today is the last date your lordship can allow. In the meantime, this will be kept open and in the meantime, they will not proceed. There will no final work on it.
If you want,
For a week or for 3-4 days.
Mr. Look, first of all, you are in conflicting
No,
stand.
it's okay.
You cannot sail in the same boat.
No, my
You have
lord,
to
here-
saw the boat in half.
No.
If you are going to try to sail in the same boat.
But end of the
Because you are challenging that 4.2.1 and 2.2 and he is in support of it. So there is no way that we can allow both.
But then, my lord, enemy is friend, my
Huh?
lord. Enemy is
enemy is friend. My learned friend was sitting,
Be helpful to all of us.
my learned friend was sitting together.
What
We are
we-
the-
what
are
what
the
I'm
enemies.
planning, I'll just tell you that item, the first one I'm dismissing. First one I'm dismissing straight away. So if you want, I'll give you time to participate. Second one, might issue notice or if depending upon the time. Because tomorrow I am busy after lunch, I'm busy. So
Second, they do not any problem with otherwise they can participate for second item.
no, but then time limit is I think 1:45,
That's the 5 PM.
Huh? 5 p.m. So you can participate.
My lord, can you
Well,
be like this, my lord? If your lordship is second matter, if your license issue a notice, that will be subject to further orders passed by this court. Because you
That
see,
can be done. That can be
subject to
done.
further
That
orders
can
passed
be
by
done.
this. I think will be,
Fair.
if your lordship,
that order can be in both the directions.
both enemies.
Otherwise, what happens, my lord, my operation fails, but the patient survives.
But the thing is that, well, so far the first case is already met of them. Second case is subject.
First case, I don't find a case.
No, my lord.
When I look at, I think you know better than me, much better. You see the CPWD manuals. You see so many tender notices. It's all legal. It's allowed. Restrictive tendering is allowed. There's nothing wrong.
No, my lord, by the second
No,
case,
my lord, the standard bidding document does not make any difference, my lord. That, my lord, I am drawing parity from the other two, my lord.
The other 2 point.
Yes.
Ah.
On
Ah.
that, my lord, let them have their say.
let it, my lord,
There
what I,
cannot be, my lord, two standard bidding documents.
No, they can. Why not? Why not?
No, they do, they have to show. my
You
lord,
see,
yeah.
this is the problem is this is nothing is signed. The document, I think he has made notes himself. That's why. It is just notes he has made. And
Like, come with the affidavit, my lord, there is no haste as such, my lord. You can wait for a week.
Because the last case. Both may participate if desired, but there is no problem. And that will be subject to the outcome of.
not outcome, subject to further orders of this court.
No, second expedition. First expedition notes closure more the observation that there is expedition condition that cannot be passed over. Therefore, they have to face the consequences. Second part is concerned.
So they have to satisfy about the, my lord, standard
Subject
bidding
to-
document. That query came from your lordship.
then both of you will have to stand on opposite side and argue first. This time.
My lord, I will go on that side. There is no problem. My lord, I will go on that side.
Very clear. If both are valid, same would be here. They will be make a very strong argument better than me.
No, because they are on opposite sides. One is against and one wants that to be. Yes.
So that's why I told very beginning that if your lordship willing to issue a notice, that will be subject to further order.
Okay, maybe we should notice in both then. Okay, but no stay, nothing.
But subject to further orders of this court, my lord. India, no, my lord.
Any decision made by the authorities will be subject to the outcome of the writ petition.
No,
That's all.
outcome or no.
You participate in the
No,
tender
my
process.
lord, that's true, my lord. But any.
That is what, that
No,
will
no,
not,
my lord.
that will not help you,
No,
that is the
I
thing.
know, that will be subject to further orders of this court. Why I'm saying, in the meantime, your lordship will issue a notice, something comes up, we'll participate, then we'll come in the application. That's why it's subject to further orders of this court. I'm not asking for subject to further. No, that's not reservation. Something comes up, in between, we procure some
It will
document.
be subject to the outcome of the orders of this court anyway.
But subject to
How
further
does-
orders of this court.
The fetching of orders will not help anyway. It will.
My lord, no, simply, my lord, that will be, my lord, again.
How much interest will you have to put?
That order, subject to the further orders of this court,
Yes,
how does it prejudice anyone?
yeah, correct. That's why I'm saying it's the father's orders
So
of this.
he has to show
Yeah.
he has to show someone that this thing is there.
No, not implied. You don't say implied. Sometimes it's so difficult. My lord, that.
You know better for who that thing is. Then,
No, but subject to further order. That's why I'm not asking, subject to
Yeah.
further orders of this court.
and
We have.
Mr. M.K. Chaudhary,
The direction of the wave, my lord,
No, direct, they will also participate, my lord.
you participate.
They will not insist upon that to.
No.
Oh, my lord, they.
No, that is why I have to dispose of your case.
That will be subject to further orders.
No, but then you have got to comply with the thing. That is what your case, so it has to be decided now. It's either this way so that you can go in appeal or
No,
whatever.
unless my lord, the statutory worship that kind of standard within the open is different for the two.
No, but then at the end of the day,
That they participated or they brought some conflict, then we get the discrimination, very difficult to participate.
huh?
If suppose this situation come, my lord, once the biddable offense, somebody has already participated, so it is a very big problem, my lord.
That is what. We cannot allow two sets of.
Tomorrow, my lord, we can file the hard copy.
Huh?
Hard copies we can file. Third one.
In terms of this, in terms of this, in terms of the NIT. And otherwise,
Then I'll.
yes, only that we can allow. Otherwise, I don't find.
Second case, my notice issued, will participate subject to further orders of this court.
Okay, right, in the second case. But again, I'll have to mention.
No, it's a minor.
Okay, right, third. Mr. D. Das, learned senior counsel for the petitioner, assisted by Mr. D. Kalita. Also, the petitioner's case is that he does not have any grievance with any of the conditions in the NIT dated
8/3/2024.
8/3/24 for procurement of fresh certified seeds of different crop varieties
Yes.
for the year 2024-25. First off, his only grievance is
The corrigendum
with the third corrigendum
dated
dated
16/4/2020.
16/4/2024,
2024.
by which the quantity of seeds to be procured by the Assam Seed Corporation has been reduced.
Yeah.
Pursuant to the meeting minutes of the Departmental Bid Committee on 10/4/2024.
Right.
First off, he submits that when the actual requirement of the state is around 19,000
In one
quintals
of the items.
in one of the items in terms of the NIT, the reduction of the quantity to be procured by the state respondent is unjustified,
Arbitrary and.
is arbitrary and unjustified. No case also.
Right.
And there is no case, both of them.
No, but please,
Only two, my lord.
no, your lordship will see, that even on 18.4. No, it's not that. Why? We'll participate. Subject, I'll satisfy.
I don't find any case, Mr.
No, I'll
Well, think
satisfy.
about it, there's no case at all.
No, 18.4, 18, no, not only that. By 18.4/2024, the list is issued by the Director of Agriculture. Your Lordship will only issue a notice. Your Lordship will issue a
yeah.
notice and subject to further orders of this court. Everyone will participate. Subject to further orders of this court.
What have I said? No, the quantity of items to be, the reduction in the quantity of items to be procured is arbitrary and unjustified. I don't find any, however way I look at it, I don't find. I think I'll pass on. I'll somehow try to do it today. Sir.
That will be better, but because the thing otherwise can be so dead.
I think at least one chance, your Lordship. I think, my Lord, they should come with some affidavit, and I am not saying that your Lordship is stopping all this. Well, it is not stopping.
The administrative decision, they might want to take a second,
what if-
second, then I think.
Because, and no, that's my annual action plan. That's my submission, my Lord. You decided annual action plan, you suddenly switched off. That's, and what is the deputy commissioner asking this a country? That's their own state government, agriculture department. That's why, contrary to all the, contrary to the requirements.
Better to pass on the money, they say unless.
Time, I'm thinking of time, that's
No, that's why I'm saying, my lord, that let a notice be issued and in the meantime, that will subject to further orders. In the meantime, there will be a participant.
No, I think I'll dispose it of both. I'll try to. I'll do it by tonight.
Tomorrow
Have to
is,
stay late.
tomorrow is the last,
Huh?
today is the last date.
Yeah, but in Maroon, they have a brilliantly, 16.4.
So you participate, we'll give you liberty to participate by today, you find.
No, we will participate. That will only, and that's why we'll participate. We have no problem with the original NIT. That's our thesis, my lord. Please, my lord, there is no problem with the original NIT. We'll participate. What we are asking is how it affects. Because today there can be,
There's no effect.
no, there will be an effect of the other side.
That is their lookout.
No, that's why I'm saying that how they will get prejudice if this matter is being taken up by this court and subject to further orders of this court. Next week, your lordship will take up this case. Next week, what is there? Something only, my lord will say that let it go. That is, he will not stay this. Subject to further orders, your lordship will hear it.
Lordship will dispose the matter, one. Second thing, Lordship, whatever decided, because it's an endless argument, both sides will argue. Better to pass out. Whatever things are, we will follow.
The problem is that I'm thinking of time, that's why.
That's why-
Time to,
So that is why I'm saying, my lord, time is the factor.
no, time to write judgment.
That's
No,
why I'm
Order, not your time, for me to pass the
No, my
order.
lord, that's why I'm saying your lordship, your lordship has to write.
I'll manage, by tonight I'll manage. I'll do it.
Let it be notice only that, man, we are asking for a notice.
Is coming again. Lordship will decided the mind is the first matter to dispose of, Lordship will consider, Lordship will take it on matter.
When my learned friend will be petitioner side, then he'll know. He's always for the government. But your lordship was, as a lawyer, your lordship was a petitioner, not for the government. There is a lot of difference. Government has got the, I'm sorry to say, I was also representing one state of a tendency objection. I have seen. Your lordship was a private, I know very well. Tendency is there only for the purpose of objection. Well, that's what I have. This is my experience. But it's a very fair, I am telling that this will be a fair, my lord. What my opinion goes, I was also representing one of the states. Well, nothing will, a prejudice happens, of course, your lordship will pass it.
Already made a mind that both.
But the thing is that I'm not convinced by your argument, that is the problem.
By end of the day, maybe today your lordship is not convinced. Maybe after affidavit, your lordship may convince also after affidavit.
No, but then in the meantime,
There is no, in the,
what will happen?
no, they will go proceed. But that will subject to further orders. That's not what I am saying. Liberty may, see, my lord, your lordship is.
Anyway, you have got time to file your tender
No,
document.
no, that's not my lord. The problem is that somebody, if they come with an affidavit, lot of things will come up. Today is the first time your lordship is hearing a motion. Your lordship, I'm sorry, your lordship is not convinced because I'm not convinced. Once an affidavit is filed by them, then your lordship will know exactly what has
The
happened. I'm
problem is
telling
they
you.
all have come at the last moment.
No,
also.
I'm sorry to trouble.
That
My lord,
16,
last one, your
16,
lordship knows.
16.
My lordship knows these tenderers. Your lordship.
No, but then today is second.
No,
Ah.
we came yesterday, we filed it. Yesterday, somehow, my lord, bad luck, my lord, it is come.
Anyway, let me
So
see.
I
I'll
think
think
my
about
lord-
it.
I think that would be my submission. I lordship will, that nothing prejudice. will
Let me
come to
see. Let me see. By the time I write, I might have a different thinking.
Your lordship will decide it. I'm just putting it before your lordship, I thought. Nothing prejudice will cause to the other side. That's deeply.
Wait, please, Your Lordship.
Yes, what is this?
One of the petitioner is aggrieved by the order dated page 35, my lord,
Ah.
where the petitioner has been directed to demolish some portion of his building which is alleged to be unauthorized, my lord, beyond the permission, my lord. Now, my lord, lordship, I will not trouble your lordship much, my lord, with the facts, my lord. Lordship will kindly see page 31 is this so-called notice before the order was passed.
Yeah.
Page 32 is my reply, where I have categorically prayed that there should be a reassessment of the building permit.
Then
No, the order, those say that my reply has been considered, but there is no reassessment. So what I pray for, my lord, let there be a reassessment of the building, because the GMDA Act also permits, my lord, that if my violations are minor deviations, that can be compounded.
so your neighbor has complained against you.
Basically, my lord, it's a allegation between two neighbors.
And you have complained against your neighbor.
I have complained against
And
him.
both of you have gone to court.
No, he went to court,
He went to court and the order was passed.
and it was
You have not
hearing
come
me,
to this.
without hearing me,
In December 23, without hearing you,
my lord.
it has been done.
Yes.
Now,
And thereafter, this
thereafter?
honorable court directed to take a hearing. And my lord will see, in the hearing, I apprised the authorities that there is a reassessment.
so now you see, you have not come to that document. That is at page 40.
My lord. Yes. Page 40, the report, my lord, your lordship will see. What does the report say?
What does
Just
it say? It says that it says on having field verification. What more do you want?
No. My lord, this is a reiteration of the order that is passed on 29/11. The same thing, my lord. Page 35, my lord.
Yes.
Page 35. The manner of deviation. So and so 2012, 2021.
No, you see that the words which has been verified. Just come here. You see now, because of your complaint, it has been found that your neighbor
My lord.
is also has not complied. He is also at fault. He has been asked to demolish.
The
You
entire
also-
house.
His house.
Entire.
And you have also been asked to demolish on the basis of your name is Chitra.
My name is
Chitra. So, and the demolition outfit you come at the top.
my lord.
Whereas Sri Rasadar Das had lodged a complaint
My lord.
against violation of so and so constructed by
Constructed
you,
me.
which was verified
Yes.
and based on field verification report.
A demand notice is issued on
A
29/11.
demolition notice.
My lord, a demolition notice was issued on 29/11. So, my lord, after 29/11, this honorable court directed to take up a hearing. My lord, to kindly see-
Correct.
Yes. On hearing, they ought to have independent. The authority.
Is there any alternative remedy available to challenge this? I don't find.
No.
This is a question of fact.
Yes.
This question of fact has been decided by having a field verification. What better thing can be done?
No. My lord will
You
kindly
want
appreciate.
you want the High Court to go and
No,
see?
my lord will kindly appreciate one thing, my lord. Just one thing.
There's no case.
My lord, the demolition notice, the field verification notice report was pursuant to prior to the demolition notice on 29/11. Thereafter, this honorable court directed to take up a hearing. Your lordship will kindly appreciate page 35 once first. Page 35, my lord. My lord will kindly. Page 35, 29/11/2023 is the demolition notice. Here, my lord will find second paragraph, my lord. Whereas the reply submitted by Citracor Dev Sharma so and so to response to the authority's so-called notice was examined carefully, and after careful examination, the reply furnished from their end is rejected by this authority as no valid ground could be furnished against the unauthorized construction in deviation of the approved plan. My lord, now page 32 is my reply, my lord. I did not even give any justification. I denied. I asked for a reassessment.
You see, if you want to challenge this report, you go to civil court. That is
No, my lord, what
that
I-
is because
lord-
this is based on a field verification made by the
My
authorities.
lord,
There's nothing else.
my lord would kindly appreciate one thing, my lord. What I'm asking for is nothing much, my lord. What I'm asking for, let the authorities make a reassessment as per my reply, my lord. They have
No, how many times did they do it?
no, they have not done any reassessment after my lord 31/7/2023.
You see, this word, which was verified and based on field verification report,
A demolition notice was issued on 29/11/2023. So, my lord, this report is of 7/3/2024. And the hearing, my lord, has taken page 36, hearing on 12/2/2024. So, after,
12 to 2024 hearing was done. Then what more do you want?
no, on the hearing, my lord, I apprised the authorities that there is a assessment pending. Please reassess my building, because if the reassessment is done, my lord, we have denied there is no violation, my lord, there is no deviation. My lord, when I have requested the authorities, they could have done a reassessment, my lord. If the reassessment brings the same facts, my lord, I may not have anything to say, my lord.
You see, this court in its order has said that instead of keeping the writ petition pending, the
My
writ
lord.
petition is disposed of by directing the respondent authorities to bring the proceedings to its logical conclusion. As
My
soon as
lord,
possible.
this,
End of the matter.
my lord,
it will be
my
done.
lord, this court did not have this materials that page 32 before passing this order, my lord. I was not present, my lord. This 29/11 order was against me. My lord, I was not even heard. My lord, I could have represented before the court, and therefore, my lord, to take note of this, my lord, a hearing was directed to be taken. If my lord takes the page 39, the direction of this honorable court, my lord.
Where is your documents or representation given to the authorities? Let
My
us
lord,
see
page,
whether
page
you have
32, reply to the so-called, my lord.
that is of 31/7,
No, yes, my lord.
23.
My lord, 29/11, this order was passed. And after that, my lord, this order was brought to the notice of the this honorable court by in a writ petition instituted by the respondent court, wherein I was also made a party, where this honorable court says that, my lord, what was the grievance in the writ petition, my lord? The respondent number 4 said that he complained and this complaint was not acted upon. This honorable court said that, okay, fine, there is a process
Look,
initiated.
this is where is your permit? Show me.
My lord, building permission, my lord, will find page 31, my lord. Sorry, page 22, my lord. It is not a case, my lord, where without a permission I have constructed it. There may be some deviations, my lord, but even, my lord, the GMDA Act, my lord, has a power of regularizing these deviations, my lord, by taking a penalty, my lord.
Oh, okay. Wait. Just a minute. You've got enough time. Yes,
So, my lord,
just a minute.
my lord.
His only case is that this page 22 has not been considered. Whether page 22 was
Page
considered.
32, my lord.
Huh?
Page 32.
32 talks of 22. That's what they're saying. 32 is just in page 32, you're speaking of this letter or this permission,
During planning of permit.
2843.
No, second paragraph, my lord.
Yes,
However, it is paid to conduct a reassessment if required and to give us some time. I am retired person having some influence. So I have asked for a reassessment, my lord.
Oh,
I said, my lord, the allegations in this so.
how many times is the assessment?
No, it was never been done, my lord.
Yes,
Otherwise, my lord, order is very specific. The proceedings have been already initiated.
Hmm.
It was directed to the medical conclusion. Their, accordingly, their part was done by the proceed. Next.
assessment has been done. Where's the question of reassessment?
No.
You go to the, if you find, is there anything wrong?
My lord,
With
your lordship
the-
will kindly take page 39.
No, is it your case that you have not violated any of the
I
provisions?
have not violated. Therefore, I am asking for a reassessment.
So they have said that you have violated. Now, who is to decide this issue? Is
I-
it
what
a,
I-
is it a question of fact?
No, what they have done,
Is it a question of law?
my lord, the,
No, Mr. Counsel, please answer.
yes.
When you say that you have not violated, they on verification have found that you have violated. Is it a question of law?
My lord,
Is it a question of law? Just answer me
may
that.
I just answer in this manner? They have brought an allegation against me in a so person.
Correct.
I have denied that.
Hmm.
I have asked that these verification, these allegations are incorrect.
Correct.
Well, had there been a lot of fact finding inquiry to be done? But their allegation, my lord, cannot be in total way. Well, what I'm asking
You
for,
have made a complaint against your neighbor. Neighbor has made a complaint against you. On physical verification has found that both of you have flouted the laws permission.
my lord, what,
And accordingly, both of you have been asked to demolish the unauthorized portions of your building.
no,
You authorized.
for the respond number 4, he has been asked, my lord, he could not even show any permission, my lord. My lord, what I'm asking for, my lord, if your lordship will kindly direct the authorities to make a reassessment and to take the decision after the reassessment, my lord.
Why?
I'll have no case, my lord.
One assessment has been done. Why reassessment?
My lord, because my lord, there is one factor, my lord.
Why
My lord,
reassessment? There should be a justification for
My lord,
reassessment.
the GMD Amendment Act 2014, my lord, makes a provision that if the deviations are minor deviation, then it can be compounded by imposing penalty. And to do
Then
so, my lord,
then you go and ask them. That's a different.
or my lord will give me a liberty
No
that
liberty,
I'll
no
file an
liberty.
application.
You go to them.
No, my
you
lord
go
will
to them.
kindly appreciate one thing, my lord. Or your lordship will take up
You
tomorrow,
see,
my lord,
this
as your lordship
matter-
is in hurry, my lord.
No, no,
I'll just try to satisfy your lordship.
no.
My lord,
No case.
my lord, I'll just try to satisfy your lordship
No.
that
You were heard on your date of hearing. When were they giving the hearing?
my lord, on the date of hearing 12/2/2024.
12 to 20.
I have made a categorical statement in my writ petition on oath, my lord, that on the date of hearing, I apprised the authorities that there is a reassessment application pending. My lord will kindly appreciate what is the report of the inquiring authority, my lord. He did not say anything, my lord. He has reiterated the earlier order and said that the High Court has directed to demolish it. My lord, High Court did not say all this, my lord.
You see, they have very clearly stated what you have, what is your, the way you have, the deviation done by you.
That is the same reiteration of the so-calls and the earlier order, my lord. My lord, in the hearing, they have not done anything more. Simply reiterating the earlier thing, my lord. So this hearing was of no purpose, my lord.
If they find the same thing over and over again, do you mean to say every time they
No, my lord,
they
my
write
lord,
an order, it
my
should be
lord,
different?
My lord, what I'm saying is, they have not done anything pursuant to this hearing, my lord, or prior to this hearing. What they have, my lord, will kindly see the second paragraph, my lord. Just I'll read it once. Whereas so and so has
Okay,
lodged a
right.
complaint,
Heard, Mr.
my lord, be cautious.
B. Kaushik, learned counsel for the petitioner. Mr. K. Gogoi appears for point number 1, while Miss A. Bhattakur appears for point number 2 and 3. That's all. Yeah. I'll pass the order later.
My lord, may I just pray for one minute? My lord, lordship will dispose it of, directing the authorities to take into note my representation, my lord. And till that time, my lord, this order may not be acted upon. Based on the outcome of the representation, my lord, based on the outcome of the reassessment, they can act upon this, my lord. In fact, I'll have an opportunity to ask for compounding of my deviations, my lord. If the reassessment is done, because the reassessment has to be done, my lord, the manner reassessment is done, it is done for the entire building, my lord. And where a percentage of a deviations can be compounded, my lord. And they have not done that, my lord. Your lordship have seen from the so-called. It says cantilevers, my lord, only the cantilevers, and that are all minor deviations, my lord. 0.3%, 0.4, 0.4 meters. Well, it's a residential house. It's not
But
prejudicing
then
any.
you see, the problem is the both of you are by making all these deviations, you're complaining that his rainwater is coming into your compound. Probably
I'm
your
not
rainwater is
complaining
coming into his compound also.
My complaint was never like
Because
that.
of those 6 inches or 3 inches or 4 inches deviation, you're making your neighbor's place unlivable.
No, my lord, if
That
I
is
may
why-
clarify, what respondent number 4 did, he came up with a complaint, my lord. I never complained. I said that he was trying to encroach upon my land in a 107 proceeding. He said, my lord, I did not have permission, whereas I could produce the permission, my lord.
There has to be an end to
Yes,
litigation.
of course, my lord. My lord, what I'm praying for, I'm not asking
It's
for
a
much.
question of fact.
And this
nothing
will
for-
not even prejudice the authorities also, my lord. My lord, it's my residential house. My lord, it's my residential. What I'm
If it's small deviations, you go ask them.
But that is why, my lord, let them be take a call on the reassessment. And based on that, my lord, I'll make my whatever is available under law. I'll ask for it, my lord. Just
And then you go to them. Why you come to
no, my
this?
lord, this
You
order.
first go there. And
No, my
then
lord, this order would remain, my lord. Just, my lord,
you go there first and you say that please do this. Then you come
my
here.
lord, I've categorically stated in by the entire petition, my lord, that time and time again I pursued for the reassessment.
Anything else? Any other?
My lord,
Okay, then what item is there? Many items.
Just a small prayer, my lord. If I may given a liberty to
Yes.
file a refresh representation, and that may be considered, my lord. I think, my lord, that
Yes. Item number 4. Yes. Fishery. Whether whose land is it? Then you found out that the title suit was in your favor. Then you want to withdraw. Okay. Item number 4. Mr. G. Uddin, learned counsel for the petitioner. Petitioner claims that he may be allowed to withdraw the writ petition, with liberty to file a plea.
appropriate forum.
Before the appropriate forum.
Yes.
Prayer is allowed. Writ petition is dismissed as withdrawn, with liberty as paid for.
May it please, ma'am. My lord, item number 6 of today's list
Ah.
and supplementary item number 18, which is two connected matters.
Tender
Tender matter.
canteen,
My lord.
catering content.
My lord, it may come up on 9th, my lord, because today, apparently, my lord will not be able to.
9th again, full bench.
My lord, on Wednesday then, or Monday, because this is long pending.
Monday. You can do it on Monday. Huh? No.
Wednesday, my lord, because this has been going on.
Wednesday is a problem. Wednesday is a motion day. It's very taxing.
Friday, my lord, next Friday.
21st.
Because I won't be.
Give some time, the 13th week. When 13th.
16th, I won't be here. So, my lord, after 26th then. Because this is a
Give a date. On the prayer, the party list the matter on 35.
item 6 and 18. 6 and 8. Supplementary 18. Main.
That's all.
How like?
well, item 19 and 20, the lordship heard it and fixed it today for instruction of the oil miller. That matter. Can it be on 14th of May, Miller?
What is this? 1920, what is this?
1920, Miller, that matter your lordship has heard at length that regarding that oil, the termination of that contract. And the lordship asked the respondent authorities to apprise as to with
okay.
regard to that 5
Okay, okay, those compressors.
compressors, yes.
Yes, yes, what do you say?
When I see instruction of it,
Huh?
we have received instruction.
Ah, ah.
We are doing separately. basically.
Okay, so it's not possible.
Well, let it be on 14, my lord. Let them place the instruction. My lord. My senior Mr. Ken Chaudhary will address with it.
After lunch, after a full bench.
After full bench.
Take time for me.
Grateful, my lord.
Next week, item number 20.
Yes,
Find affidavit, on or before second May today. But due to election duty, my lord, the
okay.
respondent will put up.
Who's for the petitioner?
I'm for the.
Any problem?
No more.
Okay, Mr.
Any big-
Mr.
big
Mr.
group.
Yes, but
Here, but now counsel for the petitioner.
not special, madam. That's
Huh?
number 1 and
Counsel for the response number 1 and 2. Please, is granted. How much time?
3 weeks after election.
You granted 3 weeks time.
Fixed date plus
3 weeks time to file affidavit in the position. Leave the matter on. Give a date.
31st.
Okay.
All right.
31st.
Yeah, who's going to start? Okay. Ah.
I want to see much of the amendment, assessment in fraud. Different of different types of. And after taking, I have I submit. So in fact, I have prepared a note. That is.
Yes.
Your voice is not clear. Is it just speaker on?
My lord. I have prepared a note, my lord. Whatever I have been told.
You put this like this so that he can see you. Huh? Yes. Oh, no, that's okay. Okay. Yes.
Or maybe we read together.
Yes.
First, I have dealt with procedural perspective. Constitution has adopted Article 226 confers power on every high court to issue direction, orders of writ for enforcement of party rights or for any other purpose. The power includes passing of interim orders without any restriction. That was the initial stage. Then Constitution 15th Amendment 1963 clause 1A was added to confer jurisdiction of the High Court to issue writ where other action arises thereafter, notwithstanding that the seat of the government or authority or residence of such person is not within those territories. It was done to overcome the judgment of the Supreme Court in case of Election Commission versus Tata Venkata Rao, the citation with regard to the High Court. Thereafter, clause 3, Constitution quoted Section Amendment 1976. It substituted Article 226 with a new article. Under clause 1, the Article 226, the High Court power to issue writ, directions or orders would be exercised. Number 1, for the enforcement of fundamental rights, or number 2, for the redress of any injury of a substantial nature by reason of the contravention of any other provision of the Constitution or provision of any act, rule, regulation, bylaws, or number 3, for the redress of any injury by reason of illegality in any legal proceedings resulting in substantial failure of justice. Thus, under amended article, the High Court continues to exercise the jurisdiction for enforcement of fundamental rights. This apart, the High Court, prior to amendment, could exercise the same jurisdiction for any other purpose, which after the amendment was restricted to redressal of any injury of a substantial nature or where the illegality has resulted in substantial failure of justice. Article 226 was made subject to Article 131A and 226A. Under clause 2 of Article 26, the power of the High Court is beyond the special jurisdiction was retained, provided the cause of action only or in part arises within its jurisdiction. The key clause 3 of Article 226 created a constitutional bar of entertaining a requisition when an alternative remedy was provided under the law. Under clause 4 of the Article 226, no interim order can be passed by the High Court unless copies of writ petition with all documents are furnished to the party in which such petition is filed or proposed to be filed, and opportunity is given to such party to be heard in the matter. The High Court could dispense with the above requirements only under exceptional circumstances where the petitioner cannot be compensated in money and costs to be recorded. Under clause 5, expert in interim order passed by the High Court shall have the effect only for the period of 14 days unless vacated earlier. Under clause 6 of Article 226, a complete bar was created against passing of interim orders in cases where such order will have the effect of delaying, number one, an inquiry into the matter of public importance, or number two, any investigation or inquiry into an offense punishable with imprisonment, or number three, any action for the execution of any work or subject of public utility, or four, the acquisition of any property for execution of public utility project. Under clause 7, the clarification contained in the original provision to the effect that the power of the High Court under Article 226 is not in derivation of the power of the Supreme Court under Article 32 was continued. Then that also inserted Article 131A and 26A, whereby the validity of any central law could be challenged only before the Supreme Court. Now thereafter, the third amendment came. Constitution 43rd Amendment of 1977 amended clause 1 of Article 226, whereby the state power was made subject to Article 131A and 220A of the Constitution. Then, my lord, it was amended for the fourth time, that is Constitution 44th Amendment Act 1978, substituted clauses 3, 4, 5, and 6 as inserted by the Constitution 42nd Amendment Act, and provided that any interim order passed by the High Court shall stand vacated. The substituted clause 3 provides that if an application is made for vacation of interim order passed by the High Court, the said application shall be disposed of within 2 weeks, and if not so disposed of, the interim order shall, that is important, stand vacated on the expiry of the 6 weeks. Now, my lord, different High Courts have different opinion. I have quoted those, my lord, citation. Clause 3 of Article 226 of the Constitution contains a provision for automatic vacation of interim order on the expiry of 2 weeks from the date an application is made for vacating an interim order. It is submitted that there are divergent views of various High Courts as to the interpretation of the same clause. The High Court of Rajasthan, Calcutta, Kerala, and Allahabad had held that an interim order gets automatically vacated after the expiry of 2 weeks if the application for vacating still is not disposed of within the same period. And my lord, the citation has given. It is the judgment of the Rajasthan, Calcutta, Kerala, and contrary is the Gujarat is a full bank. However, a contrary view is only of my lord two courts, one of two my mother. I found my lord only then Madras High Court and the Guwahati High Court has your worship now. Now, Madras paragraph is my submission. It is submitted that the views expressed by the Madras High Court, Bombay High Court, or India High Court, my lord,
Anyway,
it is submitted that the views expressed by the Madras High Court and by the Guwahati High Court that there is no automatic vacation of state under Article 26(3) of the Constitution is in my view, my lord, there is a correct proposition of law. And there, my lord, the expression shall has to be interpreted as be. And why, my lord, I am giving this justification. It is submitted that clause 3 of Article 226 is directory in nature and cannot be interpreted as mandatory, and the word shall to be interpreted as being, and there cannot be any automatic petition of the interim order found by state. Now, my lord, I have given a case law, case law instruction, where shall is to be created and made into development authority, paragraph I have substitution. It explains that the difference between mandatory and directory rules and states that the difference between a mandatory rule and a directory rule is that while the former must be strictly observed, in the case of the latter, later substantial compliance may be sufficient to achieve the object regard. Then state of Haryana, paragraph 5, it states that the word shall is ordinarily mandatory, but it is sometimes not so interpreted if the scope of the enactment on consequences to flow from such construction would not suit it. Now, my lord, I have also gone through the basic structure and my lord, judicial review. It is submitted that the judicial review.
No, just a minute. With regard to, you said case laws where shall is read as may. Para 27 explains the difference between mandatory and directory rules. And states that the difference between the mandatory and directory, that's one, the former must be strictly observed. I of what?
And my lord, in case, in the case of the later, case of the later, substantial compliance may be sufficient to effectively object to the object. Then, my lord, the shall has to be read as mandatory ordinary. But my lord, it can be read as may when if the scope of the enactment on consequences to flow from such construction is not met. If the consequences does not demand that it should be mandatory, then it should be that.
But in this case, what are the consequences
My lord, here,
if it is not heard?
if the other side is not heard, my lord, what is the effect, and my lord, what is the effect on the power of the court, that matter I have dealt with later.
What I'm saying is that when you look at 2263, does it show that the consequences that it would be automatic vacation?
Automatic.
So if the consequences are there,
Consequences are there, but the question here is, my lord, why passing an interim order, the court, my lord, size is fine. But while bracketing it, it gets automatically bracketed without application of it. So, my lord, you are watching.
there may be instances that is another issue.
Yes.
But when you read this, para 5 of the state of Haryana and others versus Kakubir Daya, but it is sometimes not so interpreted if the scope of the enactment on consequences to flow from such construction would not so difficult. But here it demands that there should be automatic vacation.
My submission will be, my lord, that once it is automatically vacated, there is no scope of for this honorable court to apply its mind again whether it is actually vacated or not. That, my lord, affects the power of the. That is, my lord, by registration, the power of the court under Article 6, my lord, that has been taken. Whether, my lord, by registration, the power of judicial review can be.
Yes, that is a different issue, but I mean, when you read the state of Haryana, I do not know whether it flows with your, it flows with your submission. Yes, basically you are saying whether the power of the High Court could be taken away by legislation without hearing the High Court or without High Court applying its concept.
Because that is one of the consequences. One consequence is that, my lord, the order gets vacated. The other consequence is that the High Court does not have the scope of applying its mind again. Because initially the order was passed, presumably, by application of fine. Therefore, whether it needs to be vacated or not, the court does not get an opportunity of applying. I have explained that as repeatedly. May I read that paragraph 5? Since your worship has put that question regarding paragraph 5 of State of Haryana. May I read that?
Yes. Yes,
It is only one paragraph. The use of the word shall is ordinarily mandatory, but it is sometimes not so interpreted if the scope of the enhancement on consequences to follow from such construction would not so demand. Normally, the word shall prima facie ought to be considered mandatory, but it is the function of the court to ascertain the real intention of the legislature by a careful examination of the whole scope of the statute, the purpose it seeks to serve, and the consequences that will flow from the construction to be placed thereon. The word shall, therefore, ought to be construed not according to the language in which it is quoted, but in the context in which it is used and the purpose it seeks to serve. The meaning has to be ascribed to the word shall as mandatory or as directory according. Equally, it is settled law that when a statute is passed for the purpose of enabling the doing of something and prescribes the formalities which are to be attended for the purpose, those prescribed formalities which are essential to the validity of such thing would be mandatory. However, if by holding them to be mandatory, serious general inconvenience is caused to innocent person or general public without very much furthering the object of the act, the same would be construed as valid. So the purpose of Article 226 is to give the High Court the power of speech or order. But that if my lord, the shall is determined to be the mandatory, that purpose would.
So one thing, see, wouldn't there be any difference in interpreting the constitutional provision vis-a-vis the statutory? Agubai Dial is a case which is of land acquisition.
You're right.
How do you get, because you see the mandate of a constitutional provision or an amendment to a constitution is a different aspect, unlike an amendment to a statute.
My lord, on my particular I was trying to find out because my lord, if shall is raised as mandatory, then perhaps my lord, it is probably different. Therefore, I try to find out the difference. That when that is that is stated, I make address for your.
In fact, see the transcription of the hearing, in the case of the Asia, is the fifth here. I think the judgment has been pronounced by the Constitution bench. We'll find a very interesting aspect in that.
That my lord,
the hearing.
High Court Bar Association case.
yes,
That has been my lord, judgment has come, my lord,
Yes,
on 29th February.
there also the court did not give it 26.3. But specifically one very important aspect which was brought in, you see the transcription, is that we construe 226.3 is procedure, giving 226.1 a substance. Now, if that is true, if it is procedure, can you not import what has been observed by the court in Kailash was counsel, wherein the written statement was mentioned as shall. But the question of the Supreme Court categorically says, yes, shall get depicted as may.
Yes.
But however, the mandate, the legislative mandate has to be followed. But in the case, it is not that without that it cannot be done. But however, subsequently, if you see the amendment being brought in the CPC by the Commercial Courts Act, and there in view of a restriction being put out there specifically, The Supreme Court says that, yeah, more than 120 days, it's 20.
That is for my bit commercial.
Now, the language which has been imported by the Commercial Courts Act is similar to the language which is being used in 2063. If this be so, can you say amended direct?
I am trying to find out bring up this point, unless my lord that HAL is it has maximity, perhaps so think I think that your hospital will be different. Yeah, my lord, read the conclusions in Alabama High Court. Sir. This attack with related. This my lord at paragraph 45. And which with respect to the bank which decided to case were unable to confirm the direct paragraph 36 and 37 of the in the case of PC and research. We hold that there cannot be automatic recognition of fees granted by the High Court who do not approve the direction to which it type all the cases in which an insurance fee has been granted on a day-to-day basis with a time frame. We hold that such blanket jurisdiction cannot be used with the exercise of jurisdiction under Article 142 of the Constitution of India. To answer both the questions in the paragraph ago in the negative. Substitute what we have here earlier, we summarize our main conclusions as follows. The direction that all the interim orders of state proceedings passed by every High Court automatically expires only by reason of lapse of time cannot be issued in the exercise of jurisdiction of this court under Article 142 of the Constitution of India. The important parameters for the exercise of jurisdiction under Article 142 of the Constitution of India, which are relevant for the statutory reference, are as follows. The jurisdiction can be exercised to do complete justice between the parties before the court. It cannot be exercised to nullify the benefits delivered by a large number of litigants based on judicial orders validly passed in their favor who are not parties to the proceedings before the court. Article 142 does not empower this court to ignore the substantive rights of the citizen. Then while exercising the jurisdiction under Article 142 of the Constitution of India, this court can always issue procedural directives to the court for streamlining procedural access and ironing out the changes in the procedural laws to ensure expeditious and timely disposal of cases. However, while doing so, this court cannot affect the substantive rights of those litigants who are not parties to the case for which the right to be heard before an adverse order is passed is not a matter of procedure, but a substantive right. The power of this court under Article 142 cannot be exercised to defeat the principles of natural justice, which are an integral part of the jurisdiction. Constitutional courts in the ordinary course should reflect from fixing a time-bound schedule for the disposal of cases pending before other courts. Constitutional court is the direct for the complete disposal of cases only access of the doctrine. Issue of prioritization such as the disposal of cases to be best placed to the Supreme Court clarification the practice. While deliberately prayers to the transfer of the High Court is taken into consideration guidelines imposed in paragraph 54. Now, with regard to my lord, although the power is in fact,
one has to also understand that there was no application of an judicial order happened with nobody asking.
nobody.
However, in a case under 226(3),
There has to
it
be.
is on the basis of an application filed and 14 days having expired.
The application is a finite one.
And that is one of the reasons why it was segregated. That although the issue of liquidity was
But
asked,
there it was like,
that is the reason it was segregated, because that is for asking, file an application. Whereas here, without an asking, also it is done.
now, judicial review, so that is structure of that matter. So, it's make it relevant. It is submitted to the judicial review is the basic structure of the constitution and no constitutional amendment may be made if the same violates the basic structure doctrine against the supposed to violate. Then my God, whenever we case of, I have the paragraph 87. It says that it is for the judiciary to uphold the constitutional values and to enforce the constitutional limitations. If there is one feature of our constitution which is more than any other, the basic fundamental to the measurement of democracy and the rule of law, it is the power of judicial review and it is unquestionably a part of the text. Then my lord L. Kumar in paragraph 78, it has been said by the Honorable Court that the power of judicial review over legislative action vested in the High Court under Article 226 and the Supreme Court under Article 32 of the Constitution is an integral and essential feature of the Constitution, constituting part of its basic structure. It has been also held under paragraph 79 that the power vested in the High Court to exercise judicial superintendence over the of all courts and tribunals in their respective jurisdiction is also part of the basic structure of the system. So my God, on this, my submission as my God from 11 onward, the effect of automatic vacation of the interim order amounts to interference with the judicial proceedings and modification of the judicial order by a living system which is contrary to the principles of independence of the judiciary as it interferes with the judicial order passed by a constitution.
Can you look at para 18 of that judgment? I put Parity in Allahabad. February. Where the spoken of 50 foot limit, where this section 254 proviso is
Interim order
no, it starts with the legislature attempted to provide for an automatic vacation of the character. The legislature provided attempted my therapist.
the legislature attempted to provide for an automatic vacation of fees granted by the income tax appellate tribunal by introducing the third proviso to section 254 of the IT Act. It provided that if an appeal in which the stay was granted was not heard within a period of 65 days, it would amount to the automatic vacation of the stay. In case of Statutory limited, this was held that a provision automatically vacating a stay was manifestly arbitrary and therefore violative of Article 14 of the Constitution of India. Paragraphs 20 and 22 of the state thus. Judged by both these parameters, there can be no doubt that the third proviso to Section 264(2)(a) of the Income Tax Act, introduced by the Finance Act 2003, would be both arbitrary and discriminatory and therefore liable to be struck down as offending Article 14 of the Constitution. First and foremost, as has correctly been held in the interim judgment, unequals are treated equally in that no differentiation is made by the third proviso between the assessors who are responsible for delaying the proceeding and the assessors who are not so responsible. This is a little peculiar in that the legislature itself has made the aforesaid differentiation in the second proviso to Section 254(a) of the Income Tax Act, making it clear that a stay order may be extended up to a period of 365 days upon satisfaction that the delay in discussing the appeal is not attributable to the assessor. We have already seen as to how, as correctly held in Foreign Overseas Private Limited versus Income Tax Appellate in the 2007 the second proviso was introduced by the Finance Act 2007 to mitigate the recur of the first proviso to section 624(2)(a of the Income Tax Act in its previous avatar. Ordinarily, the appellate tribunal, where possible, is to hear and decide appeals within a period of 4 years from the end of the financial year in which the petition is filed. It is only when a stay of the interim order before the appellate tribunal is granted that the appeal is required to be disposed of within 65 days. So far as the disposal of an appeal by the appellate tribunal is concerned, this is directed to the. However, so far as vacation of the stay on expiry of the stay period is concerned, the condition becomes mandatory so far as this.
Since pure. So, what do you read of this? You read this. What do you make of it?
That when the law says one of the has to be vacated, it has to be vacated.
Carry on reading. Carry on reading. Since the object.
In the object of the third provision to section 254(2)(a of the Income Tax Act, makes the automatic section of the stay that has been granted on the completion of 65 days, whether or not the SST is responsible for the delay caused in the delay of the appeal, such object being itself discriminatory in the sense of pointed out above, is liable to be struck down as violating Article 14 of the Constitution of India. Also, the state proviso would result in the automatic cessation of the stay upon the expiry of 65 days, even if the appellate tribunal could not take up it in time for no fault of theirs. Further, the vacation of the stay serves the revenue would ensure if the revenue is itself responsible for the delay in verification. In this sense, the state provider is also manifestly arbitrary, being a provision which is capricious, irrational, and disproportionate so far as the SST.
It says
Therefore, even if the legislature were to come out with such a provision for automatic vacation of stay, the same may not stand judicial scrutiny as it is supposed to.
so is it similar to 2266?
Because what happens, it is with the and temporary pass it is party. I find it. And for some reason, my not report cannot be because of the minor system. What is it? Cannot be fixed. Then they might not. I get the advantage. But the petition that after hearing me, both being satisfied, asking about it. And the law, so the required that the officer required to apply again. So whatever exercise the court has done is that court my lord, that
Chaudhary, what do you think about the whole act on the part of the teacher?
yes, my lord, I have to take care of that. I have made some of that.
Because if it is the fault of the court for not being able to dispose of it. Yes, he has filed the act. He has, yes, he has filed the act. But it is the fault of the court, not this.
I have taken the point.
The court. And that's the constitutional court.
I have taken the point. I speak further. I submit. Now go back. Good. Now paragraph 11. The effect of automatic vacation of the interim order amounts to interference with the judicial proceedings and modification of the judicial order by a unique instance which contrary to the principle of independence of judiciary as it interferes with the judicial order passed by a constitutional. The judicial order can be modified or vacated only by the same court or a higher court while exercising jurisdiction. Yes. Then paragraph 12. An interim order is passed by the High Court after application of judicial mind, which cannot be vacated except by an application of the judicial. Judicial discretion cannot be interfered by this. This is my subject. The High Court, while passing an interim order in an appropriate case, may limit the operation of the interim order for a particular period or give a returnable date if it considers necessary for the ends of justice. Court may also impose conditions on the petitioner to comply with while passing an interim order. Automatic vacation of the interim order would result in curtailing the judicial discretion exercised by the constitutional court, which is beyond the lawmaking power of the court. Even the constituent power of the parliament to amend the constitution. Now, my lord, I have basic info on there that my lord, judicial discretion cannot be interpreted. That my lord, considered as a case law. It is an accepted principle that no one should suffer from an act of the court. And the doctrine of actus curiae nemium debiti has been accepted consistently by the various judicial If Article 226 is held to be mandatory, it would have the effect of depriving the petitioner of benefit of judicial order passed without any fault on the part of the petitioner. That is what your lordship said. The respondent in a given case can remain contented by filing an application for vacating stay without making any effort to get it lifted or decided within a period of 2 weeks. In some cases, due to heavy tendency of court docket, the court may not be able to pick it up and pass order on application of vacating stay, and the petitioner would suffer the consequence, which is inability of the court to supplement. Now, my lord, I have given some case laws of the principles that are the act of the court of specific gentlemen. Southender holds it has been stated under paragraph 28 by the Honorable Supreme Court that no one shall suffer by an act of the court. The act of the court embraces within its space all such acts as to which the court may form an opinion in any legal proceeding that the court would not have acted had it been correctly applied of the fact, the law. Whenever called upon to adjudicate, the court would act in conjunction with what is real and substantial justice. The injury, if any, caused by the act of the court shall be undone, and the gain which the party would have earned unless it was interdicted by the order of the court would be resorted to or conferred on the party by quickly commanding the party liability. So, any automatic vacation of the interim order would be against the principle of natural justice, as the vacation of the interim order would be without hearing the petitioner and without any opportunity of hearing the petitioner and easy time. The High Court, while exercising power under Article 26 of the Constitution, passes order only when it finds the petitioner has weak case and balance of convenience in his favor, and irreparable injury would be caused if the order is not passed. Once all the relevant conditions are taken into account by passing the interim order by constitutional court, automatic vacation of the same would lead to serious adverse consequences, and in a large number of cases would violate the fundamental rights of the people. No mandatory limitation for disposal of cases application by state. In all cases, wherever a limitation is provided, it is only for a limitation. No mandatory limitation can be provided for disposal of cases by the court, especially in view of the pending can provide for passing of any adverse consequences due to non-disclosure of cases within the prescribed time. Because no one can be made to suffer due to delay and disclosure of the case by the court, and no adverse order is provided in any such case. In Abdul Rahman Antulik, paragraph 83, the Honorable Supreme Court has held that it is neither advisable nor practicable to fix any time limit for trial or offences. Any such rule is bound to be qualified one. Such rules cannot also be evolved merely to shift the burden of proving justification onto the shoulders of the prosecution. At the same time, it is the duty of the court to weigh all circumstances of a given case before pronouncing of the complaint. JNC Ramchandra Rao, paragraph 27. The Honorable Supreme Court has again stated that prescribing time limits for disposal of cases may not be in order at all times. That matter of fact, part of the case matter.
So you're basically saying that it is directly not meant,
But that is my understanding.
this Pepsi Food Limited also seems to be that type. The one you read, Para 18 of them.
Yes, that's in that line. And my lord, one aspect you also could consider, Article 223, that is the disposal of the application, the main case remains fine. The problem still remains. Only thing is, my lord, during the interim non-party adversary, although my lord, the court was pleased to pass an interim order, just by the seventh section.
What is the mischief be taken care of, operating?
My lord, with my humble submission, my lord, the mischief is that, my lord, by Article 253, the power of the constitutional court has been, my lord, not to be limited. It has been limited, that's why, my lord, it shall have to be limited.
Why it was still incorporated? That has to be a mischief. Earlier it was not there. It was a mischief. Immediately that mischief was brought in. What was the mischief?
My lord, for that, my lord, we discussed concept, the history of the matter. That's very noted. Because earlier to it, that was the fourth amendment, for the fourth amendment. 78, prior to it, my lord, it was made subject to 131A and to 226A of the Constitution.
Yeah, that is
Yes, my lord. And prior to it, my lord, the earlier second amendment of the Article 226, in fact, my lord,
But in fact, in the statement of the statement in every types of and objects, in respect of 226(3), there is no discussion. So therefore, what is the motive? In my understanding, is not available. What was sought to be, what was the aim which was sought to be?
in fact, my lord, from the first day, previous day, my lord, I had previously had placed the, my lord, the objection reasons, but nothing was stated about so not it. I that is on record. That is on record.
you think that it is for maybe
Yes. Also, yes, just to be corrected, because my lord, the first amendment was during the emergency, that was in 1976. For the second amendment. Yes, thereafter, my lord, this is going to the subsequent amendments are, my lord, of 1977, 77,
what was the basis for Madras High Court saying that this is direct?
and your practice has to statement. So, yeah, this is a citation matter. In fact, I have
Yes,
in fact, earlier I have used one for the comparative analysis of the position. There I have. So, my lord, what is the one? That has been decided by.
Oh, yes.
Okay. Computer state. Of the process.
Yes.
Where my lord Masur High Court said that it is at a direct. The view of the Rajasthan, Calcutta, Kerala, Gujarat, and Allahabad High Court about the mandatory nature of Article 223 did not find favor in the single bench of Madras High Court that took an out-of-the-box approach in Janasam Basan Board of Governors. According to the Madras High Court, none of the High Courts mentioned above considered the question from the pedestal of the most fundamental principle of law, namely that no one shall be prejudiced by an act of the court. That is what my lord consider. Access to the eminent ability. An act can either be an act of omission or be an act of commission. According to the court, if the registry of the court does not list an application for vacation of the interim release, the parties cannot be faulted for the same, and this act of not listing the matter would be an act of commission. The court felt that the law cannot be so absurd so as to say that if the court is at fault, the parties have. The court then went on to state that
Now, that has also been reflected in this High Court bar case in Allahabad,
yes,
where it has said the same thing. If an interim order is automatically vacated without any fault on the part of the litigant, only because the High Court cannot hear the main case, the maximum access cure neminem gravabit will apply. No litigant should be allowed to suffer due to the fault of the court. If that happens, it is the bounden duty of the court to rectify its mistake. Anyway, that is one side of the coin.
but that is my understanding, my lord, that yes. In fact, my lord, how the court can correct this? Of the area of vacation of the interim order, if it is listed, it is not fixed, my lord, so nobody can help. If it is listed, the court can accept that we hear the matter, with that time to accept. That also, because of the lack of time.
As I expect, if the 226(3) mandates that the order gets vacated automatically, meaning thereby the court has nothing to do. Wouldn't it apply automatically without anything to be done by the court? If it is so, then how can we say it to be directly or not? Because of the fact that the automatic happens by operation of a constitutional provision. Don't you think that then the court needs to pass an order?
My lord, whether the order is vacated or not, my lord, that order has to be there.
No.
Because my lord,
You see 226(3), it does not say automatically vacates. It doesn't say that there is a requirement of an order.
it doesn't say that.
So it automatically vacates without the court having anything to do. So don't you think, if that be so, can we say now to be directly? If we say to be directly, how do you take care of a constitutional provision which automatically vacates it? I would have understood. Filing of a written statement, you can say it to be a directory, saying that, okay, he may have filed it within 90 days, he has not filed, some time may be granted for that. But here, by operation of law, unless you set aside or hold this to be ultra virus 226(1), can you say it to be directory or mandatory for the matter? Because it is already in operation by operation of law.
Because my lord, court doesn't have to do anything on that.
Right.
No, but then my lord, the power of the court to pass an order is not limited by.
No, then the court can very well pass an order subsequent. That, okay, on an application, 14 days have passed, it has automatically vacated, for which an application may be moved. That, look here, kindly grant me an extension of with my any order that effect. That is another thing. But if it's already vacated by operation of law, where is the concept of mandatory or directive? Unless it's all it's to be ultra.
Let's follow the specific of the fact.
Yeah. So it already happened. The court has nothing to do here.
My lord, by that, way understand that, my lord, the vacation of the interim order that has been asked by the court earlier. And, the vacation, the court does not have any rule.
You have to be. But then it's not a mistake of the court also. So where is the question of directly of the
Looking at the consequences, we get it. Because, my lord, we had the discussion on the principle of, the act of the court, what it is before this. But this is not an act of the, that is what we have to purchase. So if it is not an act of the court, how can this principle also come in? I get your.
Then there is another aspect of the matter. The person in whose favor the stay was given, for reasons, for one reason or the other, the court could not pass any order or could not take up the matter. It stands automatically vacated. And who suffers? The person who had got the stay in the first, who doesn't have a chance to give his side of the coin at the time of hearing the application.
Even in a situation, if there are multiple parts and five, and district on the three. It is listed on the 14th. So on 14th day, it is supplementary. So on 14th day, the court is also empowered to pass a free order.
Yes, 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 yes. That is there. No, supposing the court for one reason or the other could not pass for whatever reason, then what happens? It gets vacated. The writ petitioner has got nowhere to turn to now.
That is a very big question. That's one of the big issues. That is there is that the order gets vacated automatically only when my lord is not listed to the court. So that makes it be on the part of the my lord. I may say, my lord, it may be the bench, or it may be the my lord business of the court. So whether that is an act of the court.
because touching on the provision. I think that be touching on the provision that section 2, article 226(3) does not apply.
No, no, what I have to say is, if you get automatically vacated, my lord, if the matter is not taken up. So if the matter is not taken up, there can be reasons. The very matter is taken. Firstly, the most important, it is not listed with it. So it gets automatically vacated. But if the matter is listed within my lord 48, the court hears it. And court passes a express order, either extending the interim order or my lord vacating the interim.
So don't we have to then say that article 226(3), how do you bring it between may or shall? Because 226(3) categorically mentions that it will be vacated
Automatically vacated.
if it is not disposed of.
What I, my lord, trying to interpret about this is that my lord automatically vacation is if it is not listed. And my lord, if it is listed, my lord, there is no problem. If it is listed and taken up for it. If it is not listed, my lord, that is a cause of the my lord registry of the case. If it is not taken up, my lord, even if it is listed, that is because of the fact that my lord, the court board is full.
No, it
Therefore, my lord, that is
will
an
apply the same way. If it is listed also, it is for the court to dispose it of, the court having not done so. Meaning that be the same analogy that once you file it. So that means once you file that section for an application for vacating, it is then the burden of the office
yes, my lord.
or the court.
Yes.
So it has to be taken up.
Therefore, my lord, it's an act of the my lord court. with all respect, that will be an act of the court. And for any act of the court, might have been important. That is fine. And that is what might have been a type of really.
Can
No,
there be another
can't
view?
we say, can't we therefore putting that amount to say that an application being filed and not being filed and not being taken up or whatever it may be, it would not make it. Because it is always the fault of the court.
Because it's not picking up, maybe might have accept to the public.
So the wording is unless disposed of, meaning that it is the fault of the court. So meaning they are right, 226(3) is bad, totally. Where the question of directory or shall or may is always the case that it has to be filed. The precondition is filing of an application. Then only the 14 days will pick up. And if it is so, then it is always the fault of the court, not to dispose of. So in eventually, we have to say that 226(3) is completely useless. Let that be the meaning then.
Can there be another way of looking at it? Number one, as my brother has rightly pointed out, the words used are that the application be disposed of. Now, even if in the right earnest, we take up the matter, we have to follow the rule of audio alterum partem. The application being filed, the petitioner says that I want to respond to it. You give an opportunity. And it's for that reason that the disposal can't happen. It's just one way of looking at it. Can't happen. But what happens is that when matter is listed, there's again an order of extension of the state till further orders. Once that order is passed, can it be said that because the extension which was passed from time to time or on that day after this 226(3) was filed is an intra-party order, and therefore there is no application of 226(3) at all. Application is filed, it's not disposed of. But there is a second order of the court. After this application comes on board, that the interim is extended. This is now fiction is created.
Before the matter is listed again, after 14 days pass.
No, it's not question of 14 days now. We pass an order, let us say you file it today, tomorrow it's taken up. Second day it's taken up. So it's taken up and then giving an opportunity of exchange of affidavit, the interim order is extended. Now this order of extension of the interim order becomes an inter-party order. Will section Article 226(3) have application?
That's the second. Firstly, matter, the order by which the application has been granted, it is liberty to specify an objection for the purpose. That becomes a fresh order of fresh interim.
Can it be interpreted like that?
Well, it has to be fresh interim order, right? Your worship, extending the order means that the earlier order is reiterated and that order is not on a particular day one. And from day one, my lord, it becomes an inter-party order. And therefore, on extension, my lord, the initial 14 days that has been completed from the passing of the first order, that does not occur at all now. Once it is extended, it is a fresh order. Assuming, my lord, I want to challenge an order by which it has been extended. And also, my lord, that it has not been vacated. The first, I have to challenge both the orders. I cannot only, being a petitioner in the case, I cannot challenge the first order only, my lord, because I have to challenge the subsequent order challenging the, extending the.
But one thing, Mr. Chaudhary, 226(3), that order would have to be made without furnishing copies of the writ petition and without affording an opportunity of hearing to the other side. But that has already been done on the day when the order of extension is given, when the respondent is there, private respondent, he has been given a copy of everything. So will 226 be applicable now? Because you're saying that's a fresh order, can it be said to be a fresh order for which a fresh application would have to be made under 2263? Because the requirement for 2263 to come into play, the application for modification or revocation, whatever, is that it has been done without his knowledge.
The subsequent order becomes kind of the interpretive order. So it is the second order of process.
There is another aspect. Can this issue be used in a different way again? Let's see this application of 26(3) has been filed. And this interim order is under consideration. Now, let us assume in a particular case, there's an gross illegality which has been committed. And therefore, the court by judicial order is staying the order. Therefore, if the order is vacated, number one, the illegality will be given the seal of approval. Second fallback of this is, let us say that you have in your hand order of stay. Now, if this stay is to be vacated, can it be done without a judicial order? Because now somebody else, let us say that we have restrained the deputy commissioner, district commissioner from evicting you. Application is filed, there is no judicial order. But can we say that the person who was restrained from doing something will now take cognizance of the date on which 226(3) is filed, assume that it is vacated, and then proceed to do something which has been restrained? Or the automatic vacating of the stay has to be given a seal of approval by the court by passing a judicial order saying that 226(3) has operated.
That is the expected number for if we reach my not straight away, the no order is required by the court. If it's like not there, not met. But then, my lord, the deputy commissioner comes and he might not execute the order against the petition. Then that plea they have to take, my lord. That is got to the petition. Then might not the court will be in a very situation because of the there is an order that took method the same for the matter of the court. That's what it comes to the court.
Probably when would a beneficiary, just for example, an order is being passed by a promotion, passed by the commissioner and secretary, PWD, thereby granting a promotion to some private respondent, and the private and those PWD officials were very much present when the order is passed. Would the beneficiaries have a right to file an application under 226(3)? Because if that be so, you will be granting a benefit to a person or to an authority who were duly present, and at the behest of the private respondent, that order gets vacated by virtue of this 226(3).
And of separately, the government department we can never control.
Because we are concerned with 226(3) primary, except yes, maybe be any cases of Board of Revenue. The Board of Revenue matters, the government is not there. Primarily, it is mostly between two parties. When they come and challenge the order of the Board of Revenue. Or just for example, DRT matter, they come and challenge under 226, any matter out there. So they don't have a standing ground. Or for example, a matter under surfacing. There also you don't get the private response, the official respondents to the effect. Then obviously 226(3) will apply. But what happens when regard to the private respondents, where the government, who is the authority who passes the order, and the private respondents out there, can they take the benefit of the 326(3)? No, they are not present. The private respondents are not present. They need to be otherwise present by 2 KB. They are not. The order is being passed, we will be hearing the respondent about.
No, my brother is trying to say that let us suppose the X was not required to be, could not have been promoted, but he has been promoted by the government. Now to challenge that, the private respondent has come to court. Now the illegal order passed by the government, we primarily find that it is illegal to state. Now, the presence of the government who has passed the order is there, but the beneficiary of that order is not there. He comes and files 226. That is the distinction my brother is trying to.
He comes because he has got the satisfied.
But wouldn't that amount to giving a benefit to the beneficiary? Although the order who have been the authority who passed the order was duly heard when the order was passed.
Even then, my lord, if an order is the private respondent does not accept the order, he can. Otherwise, most cases the government departments are there. They're standing off the.
No, I'm saying about the private, mostly if you see 226(3) is filed by the private. You don't file the government.
So they can also file. Sometimes it is the government which is not there, or maybe a corporation who does not have standing conflict, and therefore my lord. My lord, the 226(3) does not make a difference that it is a private.
No, why we are saying that the authority was duly heard? He's only a beneficiary of executing that. But the authority was duly heard, and who is actually suffering, not that beneficiary, the authority. Authority's order is being stated. That can, on the basis of a beneficiary, the authority can take the benefit on the 226(3). If you just turn it around, wouldn't that be the authority taking a benefit of 226(3) at the behest by the benefit?
But then, my lord, here, there could be authority and the, my lord, private person would have, affected by it. Not only that, my lord, the government order, but the authority order is the state, and they are affected. The private person is also affected.
Anything else?
Further, I think I have said my understanding of the method.
Oh, for the time being. Okay, let us ask the Learned AG to give his submission. Yes, Mr. Yeah, I mean, Mr. Balgopal, you're mute.
Please,
You
madam.
might-
Hope I'm audible.
Yes,
My lord, the basic issue which has cropped up is primarily for the reason. Sometimes it has become a customary practice that you get a stay order, then nobody really worries about the case because for so many reasons the case is not heard and we don't have the means and infrastructure, the judicial requirements of disposing of these cases. Just like in a criminal case, once you get bail, that is supposed to be an acquittal. Nobody bothers after that. Therefore, it was proposed that some limitations of time should be imposed to give a seriousness to these orders. Now, what has happened here? Whenever an order is passed, be it in favor or against a party, it is based on solid, valid, cogent reasons. So, on the asking of a party, the court does not grant injunction or stay. He has to comply with all the parameters which are required. Now, only then that injunction or stay is granted. Therefore, this being a judicial order, these same parameters have to be taken into consideration, even at the time of vacating of the stay. If these things are not taken into consideration, and if for any reason a stay is vacated, sometimes it can even amount to disposal of the main petition itself. So, in a nutshell, if you go through the Constitutional Bench judgment, which has been recently passed, even before it was passed, I had pointed out certain things in the last hearing that this will not find favor with the apex court, this business of vacating. I think substantially the matter has been addressed by the apex court in this case. Now, the only question is vacation automatic or vacation is not automatic? No doubt the important consideration is when you use the word disposed of. It does not say it's disposed of means disposed of in accordance with law. And once you dispose of in accordance with law, all the inbuilt safeguards that are required to be observed are mandatorily observed. There appears to be some mix-up in the interpretation of the section itself, as has been rightly pointed by Justice Luna, that there is no discussion at the time this provision was enacted, leaving it in a limbo, creating a lot of confusion. If there was a discussion, like how it has been discussed for various other provisions, it would have been different. It seems to be a very non-serious introduction. But whatever way it is viewed, whether it is taken that it means automatic vacation, even in that event, there cannot be automatic vacation of a judicial order just because a time limit is prescribed. What is more important is you can vacate a judicial order only by a judicial process. If the conditions which existed at the time the judicial order was passed continues to exist, even at the time the vacation order is going to be passed automatically, that would amount to a complete mockery of the proceedings. So therefore, question of automatic vacation that does not arise at all. It cannot arise. And I think that stands settled today. But the whole confusion is that balance has not been there. The balance which was supposed to have been there, that doesn't seem to exist in this matter. All the judgments are very clear. A group of high courts stating it can be done, it's directory, it is mandatory, all these things are fine. Whatever way we look at it, a judicial order cannot be vacated through virtually a non-judicial process, just fixing the basis on time. This cannot be done. Because if this is done, there would be no meaning. Well, it's not, when you grant an injunction, it's a very important thing for a litigant. No court automatically gives. The first question is, why should I give? You convince the court. You establish the credentials, your prima facie case, etc. Only after the court is satisfied, this order is passed. So the judge disappears, honorable judge disappears from the scene, everybody disappears. It is an automatic process. That is unknown to our method of civil jurisprudence. That may not be correct. And I think the Supreme Court has, in a way, largely looked into this. And maybe the only comforting factor is when you use the word disposal, there are certain inbuilt things. This is my humble submission without going into these various decisions.
Okay, what do you mean when you say dispose? Unless
Dispose-
disposed of. Yeah.
When you use the word disposed of, there is a difference between dismissed, admitted, and disposed of. Whenever you use the word disposed of, it doesn't mean that it is a rejection from the side of the court, as is sometimes misunderstood. It only means that you have been heard, your contentions have been taken into consideration, And based on those contentions, we are passing an order. It is something short of dismissal. It is not dismissal. Disposal means it's clear that the rights of both the parties have been adequately considered. And whenever you use the word disposal, I don't think any litigant or any counsel would have any serious objection to it, because it is really giving the legal process. And there is a huge difference between the term dismissal and disposal. So even if you see the words, it doesn't require any specific interpretation. Disposal. The Supreme Court disposes so many cases. They don't say either they say admitted or dismissed. Disposal will be there where they are giving the reasons, and this is which means everyone has a share to his right in that disposal order. Everything is considered. So that in my view is it's like that. I mean, it's a very protective word. I think the lacuna of natural justice, that is taken into consideration when a matter is disposed of. The safeguards are there.
So what you're saying basically is that there cannot be an automatic vacation of a stay order.
Please. Cannot. Because if you have an automatic vacation of a stay order, then what is the use of going and convincing the court for getting that stay order? If getting the stay order is automatic without any application of mind, then the vacation could be automatic. No court will automatically give any interim order. The first bridge you have to cross is how to convince a court on this. It is nothing less of, in sometimes, of final disposal in certain cases, unless the court is convinced, yes. Because the court knows the dangers of granting and not granting the order. So after you apply your mind to all these things, after you have quoted so many decisions of the Supreme Court or a High Court saying this injunction should be granted or it should not be granted, you put away all these judgments in the background. And just on the question of time, this time is overboard, that it's not done that way. It will have no meaning that way. It will be making a mockery of the whole situation if you are going to follow this process. So if this process is followed, then justice would definitely be a casualty.
The AG, one thing,
Well,
if you are submitting that a judicial order cannot be vacated by a non-judicial order,
please.
wouldn't that then imply that 226(3) is redundant? How do you take care of the 226(3)?
You see, when Supreme Court has been dwelling in the matter, it has also applied the principles of 142 and 140, which maybe a High Court is not endowed with. But on the basis of principles, if a law is laid down in terms of 141 or 140, then it has automatic consideration or observance by the higher courts. The main thing which I've read this many times, it somehow lacks absolute clarity. It says something on the right side and something else on the left side, it is susceptible to different interpretations. Both of them may be right in their own way. So if this whole provision has been simplified, and that could have been looked into only if reasons are given in the objects in enacting this particular provision. This has not been done. This has been done basically in a hurry to see that more populist in nature, that litigation should be, the time for litigation should be curtailed. So they thought, let us put it like this. They did not know the judicial repercussions if that type of blind method is followed. When we go into that, then we are going into something else. Like I'm just taking out.
And also not taking into consideration the explosion of the dockets over
That's,
the years.
that is the point. That's the point. We don't have a system where a lawyer is asked to argue for a few minutes. He may start and it may continue. So like that, there is no time limit fixed for anything as far as the process is concerned. Unlike in many places where they give you only 29 minutes to argue. And on the 29 minute, a bell is rung, which means your term is over. We don't have that. So we have a very long, I would say, very comfortable process by which the cases go on. So if there was a time limit fixed for disposal of the main petition and then a time limit for the interim petition, then it would be different. Now, when the matter itself takes on such a long time, it becomes very difficult.
So under such circumstances,
Ah,
can this court say the provision to be directory or mandatory? If you are saying that the provision is redundant,
Redundant means the mandatory application of that provision.
if it is not mandatory, what is there? Then nothing remains.
That is it. It is not mandatory.
It is not
I would-
mandatory, then nothing
if-
remains out there.
If we go as far as mandatory provision is concerned, then justice will be a casualty. So when you say whether a provision is mandatory or directory, it does not depend upon the terminology used. We have to see in the circumstances in which it is used and how much the cause of justice would be advanced. Terminologies by itself, like may, shall, etc., can be used in different contexts, in different matters. So as far as this is concerned, irrespective of whether it is mandatory, whether it is directory, what is more important is whether this process can hit the gates of justice. That is the most important, not the terminology used. And if it can, then it would be really difficult to get into it. Now, if just to give a small definition of the word to dispose of means to determine the fate of or to exercise finally one's power of control over it to claim what it is to be. This is just the legal dictionary's meaning of disposed of. So I think though provisions have been provided which are inbuilt safeguards, yet those provisions have been watered down by some of these terms in this very provision, which in a way are a little confusing and little contradictory. So therefore, we have to only go into this question as to whether the ends of justice would be served if in a contingency like this, we have to go through a process by which the interim orders are granted. Because if you can just see, if the petition is admitted at one stage without any stay, and at the time of admission they give reasons, but at the time of disposal they don't give reasons. That cannot be. That won't be a proper judicial order. That is the same thing which is happening here when you are vacating an interim order. The same provisions which are there. Otherwise, there should have been a change of circumstances. Then it can be justified. Warranting a different view. Circumstances, everything is same. Nothing has changed. And then you put the time, that is not a proper way of looking at it. That is my humble subject. We can use any terminology. But is it fair? Is it proper? These are the things. We cannot have, it is not, it's a question of somebody's valuable right, sometimes inalienable rights, which are being protected. Just by a stroke of time, can it be whisked away? That will not stand to reason. And I think this Constitutional Bench judgment has swayed in its favor. So we have got a lot of guidance from it.
The
Because
problem, problem lies with paragraph number 26 of the Constitution Bench judgment, where the Constitution Bench categorically mentioned that we are not dealing with 226(3). And
Correct.
further differentiated those provisions in that say, the differentiated 226(3) why being not taken is on the
Right.
ground that there is an application file which is not here in.
That's right. I agree. And in para 6 of the same judgment, they have clearly said that if injunction or stay is granted based on certain reasons, you can't vacate it unless you refer to those reasons, just by point of time. Para 6, it is categorically mentioned. That takes care of it.
Correct is the submission.
Right, that submission which has been mentioned in para 6, that goes undisturbed because that is a factual submission. There cannot be a second opinion on that. There cannot be a second opinion on that, irrespective of whether the apex court said that we are looking into it or not looking into it for any particular reason. There cannot be any other views as far as para 6 is concerned. That in a way sums it up. That if you because judicial order means it's based on reason. Based on reason means the party has a right to be heard. All those things come into effect.
Or
So
for
on
just
the
for
one,
example, if we say that that order which is being passed out there would be continued till the disposal of the repetition
correct,
in the I, which is
correct,
being filed
that's right.
for vacating, that would also amount to a disposal.
With the protection, inbuilt protection, because you are continuing the interim order.
So that would
That-
also amount to a disposal of that application.
That's right, up to the final stage. So
Yes,
that
so
means the court is aware of the fact that this cannot be vacated. Because if it is vacated, it may result in disposal of the main petition itself. So therefore, when you go into interim order, we ask for interim order because if you don't pass this interim order, I'll have nothing substantive with the case to disappear. So that is the point. That's a correct view. It's very right.
Okay, but that like that, that whatever disposed of. Disposed of matter that has we go to back to that is a matter of time of the case.
But with regard to
The determination of right of the person.
determination
Yeah.
of right. But insofar as application under 226(3) would be concerned, it will be limited to that aspect of the stay.
Only. So that will not finally matter decide the right of the person.
No, not finally decided, they will decide the issue with regard to that stay order.
So that is a pre-condition. If it is not to dispose of, so this can be read as my if it is not so increased by this one of by the
To see which is makes an giving such party an opportunity of being heard, makes an application to the High Court for vacation. And what is to be disposed of is that application.
not the main.
No, not the main. So under the only mentioned the debate.
But what I was trying to point out is that the disposal effect means why not it has been dealt with by.
That is what I was saying. That if we say that that application which is there, the interim order passed earlier shall continue with the disposal. In that application would amount to a disposal of that application.
Then we can other part. Process takes up the decision of application. Is that how will decide the which will become finally. if the IA is not disposed of, then my lord, 256 will take it. But if we will hear the IA along with the main petition, then my lord, then automatically. Am I clear? So in any case, that application IA has to be disclosed. That's the case. If I not closed, then my lord, that is. Perhaps of the constitutional nature has a great sort of various possibilities. But while amending it, one of the problems is without as the lordship has pointed out, the fact of the docket now, that was perhaps not applicable to my.
But at that point of time, they thought that, okay, because they made it initially, if you see, you can say, they made it similar in terms with order 39.
Yes, yes.
And that you have to file an application and that application has to be disposed of within 30 days and all, these aspect was there. Here they made it 14 days. But here they say about automatic, whereas order 39 says about that you are a mandate is being imposed. Here they have, I think it was a period at that point of time which happened in 1978, 78.
70. And I thought this platform, the exponential growth of cases, that's not
Because you see, it is not a case where we are having out here 57,000 cases. But in places like Allahabad High Court, you are going to Rajasthan High Court, these people have 10 lakhs, 6 lakhs, 7 lakhs cases. How do you take care for and with so many, don't have that so much of judicial infrastructure. And the moment you keep on filing those applications, it will be next to impossible. One has to look into those aspects.
Okay, I think, so we'll reserve the judgment. Yes, yes, it was, very much, it was. Only one thing, it appears that, that case regarding the Income Tax Act 254, that seems to be quite similar with the issue that has been raised. That on a particular paragraph that you have. Because there also the issue was within 1 year. If it was not disposed of, it would automatically be vacated. Supreme Court said no. Anyway, I heard Mr. K.N. Balgopal, AG Nagaland, and assisted by Miss M. K.T. No. Yeah, the additional lawyer. Yeah, additional AG.
AG.
Additional AG. Also heard Mr. M. K. Chowdhury, Learned Senior Counsel. Learned Amicus Curiae, assisted by Mr. M. Sharma. Hearing concluded, judgment reserved. Actually, these judgments though you did not provide. You have only given the citation. You've got it. Many books. Thank you. Can we have it photographed? I mean, photocopied and okay. But otherwise, going through will take some time, no?
or if there was a direct method, I can take it print out.
Print out, there's a print out. Item 7. What's your name?
Anna.
Huh?
Anna.
Okay, okay. You look like the lawyer who used to do that arbitration case comes to I got. They had these photographs. Huh? Lisa. Lisa. So I thought I'll ask you a question that was troubling my mind with regard to the arbitration act. Yes, item 7. Yes, when will the you are not who's for the other side? What do you want?
They were The last one.
They were asked to find out whether when the HO will be open. Who?
No one present, I coordinated with them, they said, take a
Okay, when? Give a date. Right, right, the petitioner's counsel is present, however, no one appears for the respondent to state when the newly created HOA will become operative. Accordingly, list this matter on. Yes, madam.
Okay, I will take for 3 weeks and start my activity. All of the title is so pending in civil court.
So title suit is pending. So the no speaking order can be passed. Huh?
Yes, sir.
Because of that. The failure affidavit.
That may be fixed, Lord.
Huh?
That may be
Okay,
fixed.
mister.
It's wrong.
Then counsel for the respondent number. Respondent. Submit that he will file affidavit within 3 weeks.
That may be fixed,
This
Lord.
is the matter on, give it.
Like-
19 and 20.
So my learned friend starts my lord. Because of the order passed by your lordship.
What is this matter?
Nothing would recollect that the installation of the gas compressor.
Those that.
My lord, the last order, before my learned friend starts. My clients have my lord copied in the wrong code.
Huh? Okay.
My clients have asked me why, how can I make this submission? If the lordship kindly, my lord, reach the order, second paragraph of the last order, my lord. 29/4/2025.
29 for 24 years.
My lord, the second paragraph, my lord. List is matter from 2/5/2024 today. On which date Mr. Ankar Chaudhary, Learned Senior Counsel, shall obtain instruction with regard to the status of the air compressor to be fitted in Pakistan, Balimara and
Yes, yes.
which he submits that can be
Which Mr. Kane Chaudhary
That's
submitted.
very clarified, my lord.
That will be done.
That's very clarified.
Yes, so.
So
So-
instructions I have got.
Yes.
Instruction I have received. My lord. My instruction is that, my lord, they cannot complete, as they have changed because of two factors. Number one, which your lordship said about this, my lord, this air compressor. Air
Yeah.
compressor comes, my lord, after the gas compressor. Gas compressor have not come here, and the India oil compressor has already ordered those, my lord.
Gas compressors have not come.
And the
Air compressors cannot be functional without the gas compressor.
gas compressor and
Gas compressors.
And my lord, my learned friend, on that day, the guide, so that there was been extension,
They were?
in the extension, my lord. They said because, my lord, the permission was, we wrote a letter that, my lord, the equipment can be bought. Those are, my lord, the gas compressor.
Okay.
And now, my lord, gas compressor has been, my lord, ordered for by the.
So the gas compressor is in respect of one site which is coming from Mundra Port. Where concern with the five. I think my learned friend is confusing my. That gas compressor was to be imported in respect of one site.
One sec.
Yeah. There are 8 sites.
Three is not working.
Three, my lord, we say within 24 hours.
3 within 24 hours. 2
We
within.
say within a week. And my lord, other 3, my lord, in respect of 2, my lord, in fact, we acquired the land during the subsistence of the period. Then my lord, Tea Garden also agrees. Now conversion part government is taking over. Over that we don't have any cost. And my lord, earlier it was the deputy commissioner who was entrusted to convert the uses of land. Now, my lord, it is the state government because of the change of the policy.
Anyway, now yes, so according to you, he says that there is only one gas compressor.
My lord, my that it can be completed. That was the
No,
instruction
that is their contention, my lord. I have already shown. My lord, what we can do, in fact, we can give a video presentation also, my. We are ready with it. And live CCD camera also we can give, my. How can they say all these things, my lord, when they say that by 22 to 25 will inform, by 28 to be installed? It was at that state, my lord, they never reverted back to us. There was an agenda minute of joint meeting where this decision was taken.
We had given it part of the 15 days notice before termination. Because at least people thought going to install within a day or a week, we could have done it.
That
My lord, my
Yeah,
only
yeah.
humble submission. Now, if they are to do it of their own, or if they are to do it to some other agency, they will have to give according to the other terms of the condition, 300 days mobilization. Then, my lord, whosoever bids for the work, even for the price, bids today's contract. We say we'll do at that price.
No,
Otherwise, we'll go bankrupt.
no, he's saying that they're going to do it in-house.
Yes,
No, even for in-house, my lord, they will have to spend money. Whereas they have already, I have spent my money on. It's a.
Why
no problem.
why don't you take over what he has done?
Yes.
my lord, so far as the first one question is regarding the equation of land. Acquiring the land.
No. Forget those. I'm not on those at all. I am only on those 3 compressors which can be completed within 24 hours.
My lord, one will do one thing. They say we cannot do. We say we can do. But let the matter be called after 1 week. We'll do it.
Why 1 week, 24 hours you
No,
said?
that's why I'm saying that in respect to other 5. Let them give it. Let them, my lord, they have to do one thing. I think he's going to do like what?
No, my lord, we have actually replied there, and my lord, the subsequent, the order that was passed by the Honorable Court to dispose of the presentation. If your lordship, my lord, reach the disposal order, your lordship, it is very clear.
Clear
it
that,
cannot do it. It cannot do it. And this is a matter of determinable contract. And it has been determined.
No, I
Go and ask for damages.
My lord, it is not a
And
contract
land is not a-
determinable in nature. I think my learned friend has misconstrued the meaning of the expression, what is a contract determinable in nature. A contract is determinable in nature when it is determinable at the volition of the parties. There is no such clause in the agreement. He is making wrong submission. How can it be a contract determinable in nature? It's not a contract determinable in nature. And a contract determinable in nature has got a definite legal connotation. If one says it will not do, my lord will kindly permit me to place one document where my lord will. My lord will kindly come to these minutes, my lord, at page 268 of the writ petition.
Yes.
Kindly see, my lord. This is a joint meeting between the petitioner and the Oil India. Kindly come to 4. Recommissioning inspection notice by Devi for 3 installation will be given by 22-23, and commissioning of 3 installations will be completed by 28-2 as confirmed by 20. So this was the decision, my lord. Please come to page 269.
Yes.
Kindly see, my lord, the last para. In the Bagzan side, we are ready for commissioning of the compressor on 26/2/28/3. So we request your good office to kindly give us clearance of connecting the pipeline to the hookup point and inform us the date between 22/2/23 and 25/2/23 to work at your convenience. They never replied. And now they are saying we cannot.
And termination was on
10/4, my lord. They never replied to us. It was a joint decision taken in the minutes of the meeting, as recorded in the minutes of. My lord, 34 crores we have spent in this contract. How many amount of compassion they should have, my lord, apart from legalism? And as Nephi has rightly said, it is a public money, my lord. If tomorrow this money is to be written
How
off,
much work have you done this time, Mr. Chaudhary? How much work have you done?
One of the instructions they were simply can be taken. Instructions my lord, the second set here of the first instruction says oil subject in-house gas compressors are to be installed situated at all own site land. And after the termination of the contract on the challenge, oil has no relation to the petitioner and accordingly, the status city of the site or any other activity does not arise. Then next week you have also to find.
You have given me a copy.
My second is more important.
Yeah.
With reference to the trading rate, it finds into the status of the greenhouse gas compressor to be fitted at Baghdad, Balimara, Islajan, and Sabua and Parity. Number one, new land is procured at Baghdad by oil and necessary civil jobs are going on. For Balimara, Rekulajan, Sabua, and Barekuri, existing oil land has been identified and civil jobs are going on. For all the above, purchase order for gas compressor and other ancillaries are placed. Now, so far as land is concerned, so my lord, so far land is concerned, my lord, under the contract, it was their job to, my lord, get the land. That your lordship will find at page 124. 125 is the relevant clause 6. That is the scope of the work.
well, he said they've never brought this on record in the affidavit.
This is on record. I'm reading from your affidavit. My lord, page 125, your lordship will simply come. 39, 6697.
125.
125. It starts from 124, details of the scope of the work. 124, but the scope of the work.
Yes.
Then page 125, clause C, your lordship sign. To acquire or hire land required for gas compressor plant, there shall be sufficient space for addition of 20. It is there. They have not been able to carry out till today. And therefore, my lord, the oil has taken its own land and their mother there subject to work. That's the order for the. And
Yes.
so far as my the determinable nature of the work, your lordship in the contract agreement itself. My lord, the termination clause is there, where it is stated, my lord, several, my lord, aspects has been dealt with. Number one, that your lordship will find that, my lord, page 108.
Yes.
108, clause 13 is the termination. My lord, your lordship has already noticed that previous day, my lord, they were given ample opportunity to extension of time in again. Then, my lord, terminate 13.1, termination on expiry of the term duration. This contract shall be deemed to have been automatically terminated on the expiry of the duration of the contract. The contract extension period is exercised by the company under the provisions of the contract. That force measure, my lord, they have never invoked because that has to be invoked. Then, my lord, termination for unsatisfactory purpose. Clause 13.4. So, my lord, because of their unsatisfactory performance, they could not perform, my lord, in time, that has been, my lord, terminated. So this is a, my lord, contract terminable in nature. And clause 14 specifically states about, my lord, the dispute resolution arbitration. And this is a matter purely commercial contract. No public law remedy can be involved under the code.
This is a,
On a public law remedy, it is a.
cannot be invoked.
Yes, it is not a statutory contract, it is a purely commercial contract. And my lord, that has been terminated, and the remedy is in, my lord, the arbitration. And from, my lord, this is not a case where, my lord, public law remedy should be. And my lord, and it could. Like that day, I have. At least it is.
Yes. What are the decisions? You have placed, I think, 2019 5 GLP 97.
Yes.
And one was 2022 5 GLP 79.
799. And my lord, one WPC 91.
19 WPC. What is that?
That is unreported judgment, my lord.
WPC, what is the number?
9019 of 2009.
Yes.
That was Victor and Compressor.
Para
Yeah, my lord, para 10 to 13.
10 to 13. And what about 2019?
2019, my lord, relevant paragraph will be 32, 33, and 34.
13, 13, 33, 34.
32, 33, and
32, 33, 34. And what about 22?
22, the 5 JLT is paragraph 21 to 25 and 28.
And in the present case,
And my lord, presently I have given my lord 1991, volume 1, especially 533, Indian Oil Corporation versus Compressor Gas Service.
para
Paragraph 8, 9, 11, 12, and 14. 8, 9, 11, 12, and 14. That is it. And my lord, another case. 2003, volume 1, DLR.
2000?
2003, volume 1, DLR. Page 619. Paragraph Star India Limited, paragraph 6, 7, and 8. And my lord, another decision of the Supreme Court, my lord.
2015, 7, 7 to 8.
SCC, is 728.
Yes, para
Paragraph, my lord, 55 and 69 to 70.
that's all.
Regularization was to be done under within 300
Huh?
days and more than 2 years under this is not to be done. Regulation itself under this is not. And we get given it enough. Enough, madam.
Just a
Regulation here what will find a still complete.
What did you say?
That my lord, regarding that mobilization time,
Page 98.
page 98, my lord, clause 2.2. That was to be done within 300 days.
Okay, with regard to that, I think the stand that they took was that you had given extension 1 and then
Twice.
twice till 31/1 2023. Page 264.
Yes, no, we did a termination notice, then on the.
Then after that, there was something else also.
On their request, my lord, we had given.
Then, then you had given this letter dated 8/4/23, that the certificate is valid for 6 months for this.
Yes, my lord, but that is not an extension, my lord, because they wanted to bring those, my lord, gas.
That is not an extension of the,
Because without that, they could not have brought, they requested for a, my lord, note that that is not an act.
that's all.
By your reply, my lord, just take 10 minutes time.
Just so many documents. now. Yes,
My lord, I have shown that minute where we agree that by 22 to 25, we'll intimate them and they will do the hookup on 26. Because they say to do it. Then on a page, my lord, 60. 269, my lord.
Yes.
That's the letter we said. People also to kindly come to 269 one.
Yes.
In Bagzan side, we are ready for commissioning of the compressor on 26 to 23. So we request your goods office to kindly give us the clearance for connecting the pipeline to the hookup point and inform us the date between 22 to 23 to 25, 23 for to work at your convenience. So the timeline which we agreed upon is the minute was that by 28 were to do. Then on 20 itself we wrote that we'll do it on 26. Therefore, please let us know between 22 and 25. They never responded. Now, my lord will kindly come to page 224. (13.0).
Yes.
Commissioning of the compression service should be completed by the contractor within 300 days from the dated letter of award. Now, my lord, these 300 days can extended by mutual contract up to 28 to 23. Let us not even take note of other days.
Wait. Extension of time
Yes.
is till 20.
8 to 23.
Ah,
I'm clear, my lord. Even thereafter also there is extension. Let us, for the purpose of the point which I'm trying to make, let us take 28 to 23 is the last day. Am I clear, my lord?
no, page 264 is there.
Yes, it is there, my lord. I'm saying, yes, this is the second extension. Then my lord will kindly come to page 290. Sorry, 268. 268 is the minute, my lord.
Yes.
Kindly see. Pre-commissioning inspection by Messrs. Debbie for pre-installation will be given by 20 to 23 and commissioning of pre-installments will be completed by 28. So now, my lord, the contract stands extended. Rather, the period of commissioning stands extended to 28 to 23.
Correct.
Now, my lord, on 20 to 23, we wrote to them that we'd like to commission the one at Bagzan on 26. So please inform us by between 22 to 25. Page 69. 269. Page 269. So they never responded to this communication of 22-23. Instead, my lord, they terminated the contract on 10/4. Now, my lord will kindly come to page 224 to appreciate our contention. Once again, last two sentences. How to construe the contract. Please come to page 224. Last two sentences. The date of commencement of operation shall be considered. Page 224, last two sentences. The date of commencement of operation shall be considered from date on which first compression service is successfully commissioned. So, my lord, if they would have permitted us, Artisan would have commissioned on 26 to 20 within time. It is not our fault. Now, my learned friend says, contract is terminated, go to civil court, file suit for damages. Is that the law? My lord, I will cite two decisions from the Supreme Court, which will belie what my learned friend is contending. Lordship knows this Radhesham Agarwal, Kasturi Lal, Mahabir Auto. Until then, the law of contract was that 226 court will interfere only at the threshold. That is, at the time of entering into of the contract, whether there is violation of Article 14, that can be examined. That was the law until Mahabir Auto took. Then, my lord, that UP case,
How much time will it take?
2 minutes. Srilekha Vidyarthi. Now, paragraph 24, my lord, kindly see how lucid the Supreme Court is. I don't know whether book is there and the citation is. I'll just end. Or it's a lot of like just
No. There should be citations only.
Two
Correct.
citations. To counter the argument of my learned friend that once the contract is terminated, 226 court cannot do it. You go to civil court, go to arbitration. It is absolutely wrong. Finally, my lord, the citation is 1991. 1 SCC 21. Para 24. I'm reading in my lord. Lordship will definitely read it. This state cannot be attributed the split personality of Dr. Jekyll and Hyde in a contractual field, so as to impress on it all the characteristics of a state at the threshold while making of a contract requiring it to fulfill the obligation of Article 14 of the Constitution, and thereafter permitting it to cast off its garb of state to adorn the new robe of a private body during subsistence of the contract, enabling it to act arbitrarily, subject only to contractual obligations and remedies flowing therefrom. See the language, mild. The state does not play the split role. When it comes to entering of the contract, you follow Article 14. Once you enter into the contract, you are not required. Then you become a private body. And so, it is really in the nature of a personality as a state, which is significant and must characterize all its actions, whether whatever field or not the nature of function, contractual or otherwise, which is decisive of nature of scrutiny permitted for examining the validity of the text. The requirement of Article 14 being duty to act fairly, justly, and reasonably, there is nothing which militates against concept of requiring state always to act, even in contractual matters. There is a basic difference between acts of the state, which must invariably be in public interest, and those of private individuals engaged in a similar activity, being primarily for personal gain, which may or may not promote public interest. Viewed in this matter, in this we find no conceptual difficulty or anachronism. We find no reason why requirement of Article 14 should not extend even in the sphere of contractual matters for regulating the conduct of the state. So, my lord, it's a misnomer that Article 14 can be judged only at the threshold, not after entering into the contract. In my understanding, my lord, this judgment of the Supreme Court has not been overruled or by even by dissented to by any larger bench of the Supreme Court. Now, my lord, recently, very recently, that is 2023,
2023 2023 2 SPC 703 paragraph my lord, the law has been pressed right from my lord that Agarwal states. I'll read my lord para 82.5. After contract is entered into, there can be variety of circumstances which may provide a cause of action to a party to the contract with the state to seek relief by filing refusal. My lord, what I am complaining? What I am complaining is I was ready to start the compressor by 26. You did not permit. And your clause 13 at page 224 says, see, I commissioned one of the unit, my lord, then it amounts to commissioning. Are you not acting arbitrarily, my lord? This arbitrariness, can it be looked into by 226 court? For this, why should I go to my lord civil court? Where is the disputed question of fact? Therefore, my humble submission is, my lord, it is a clear, open and shut case where, my lord, your lordship can exercise the power of the and give relief to the petitioner. And my lord, give us 48 hours. If we can't, then lordship will take the call. Give us 48 hours.
Last week you said 24 hours.
Not even I am saying 24 hours.
It's like,
I am saying 48 hours, the order will be written, it will be communicated, they will have not reached it, so and so. All right, 24 hours from serving in the order of the copy of the order.
okay, yes.
My lord, I was stopping anything on side. Let me one question I was emphasized regarding the acquisition of different tender. There, my lord, there was a typing error on this clarification for 20, my lord.
It's okay, you have made a submission, we accept that you have drafted. No, one thing, you see, he has written a letter to this meeting, minute, that is there. That was made on 3rd February 2023, page 268.
My lord, 3rd of February 2021.
23.
Sorry, my lord.
Is it 23 or 20, 23?
Yes, right.
23, my lord.
It will be 23. Then, my lord, on February 20, February 20, 2023, 20th of February.
No, what do you have to say about this meeting, minute? Does it mean that there has been an extension of time?
It's not an extension of time.
Then what is it?
The reply, your lordship will get, they will get at least 73. We have response to my lord, thereafter, my lord, we have responded.
You have to respond to this.
Yes.
It's page 268.
273.
270. Yeah.
273. After the part, my lord, in fact, it starts, the sentence starts at my lord, 274. This, the subject contract for gas compressor service in these installation of oil was scheduled to be completed in early 2020 as per provisions therein. Your default in execution has already delayed the project services by almost 1 year now, despite regular follow-up from our end and assurance from your side. After 1 year of delay, you have now self-declared that the compressor setup at Baghdad, only one location out of the 8 locations is ready, and you need clearance from oil to connect the pipeline to the hookup point without even notifying company about a joint inspection and witnessing the mechanical completion, etc. No improvement in the site job was noticed with respect to other 2 locations at which the compressor package were also said to be arrived more than 3 months now. As stated in your attached letter dated 20 February 2023, 4 more compressor packages are still in Asansol, West Bengal, and yet to arrive their respective sites. Moreover, you have not mentioned anything about the 40,000 FT gas compressor, whether you will be mobilizing the same or not, and what is the current status. View above, we request you to complete the entire job as per the provision of the contract within first March 2023, failing which we shall have no other option but to take necessary matter action. And my lord, in the credibility opposition, also my lord, we have an communication.
No, where are you reading against you? Where are you reading? Where is that portion against you? You are reading 274.
Yes, my.
No, you see, first of all, what do you say, what is your, finding on this page 268?
268, my lord, on that matter, we had a review and therefore, my lord, this has been considered and finally it is paid in view of, my lord, the,
No, review of what?
of what has happened, my lord, and, they were given opportunity up to first March 2023.
They were given the pre-commissioning inspection notice by the petitioner for three installations will be given by 20/02/2023. Now, at page 269, he has given a letter on 20/02/2023.
Same day.
On the same day. On the same day as their letter. No, now,
The minutes was of 20 and our letter is also.
no.
Oh, sorry,
3-2,
sorry.
3-2.
Sorry. Submit by 2. I'm sorry. Minute was of 3-2. We were asked to submit by 20. So we did it on 20.
So what is your reply to this page 269?
My lord, on February 20 itself, my lord, we have already taken the decision and communicated it.
No, but that was, now, when you have given them time till 20 February,
My lord, we have given the first of March.
2020.
20 to submit.
Yeah,
And
so-
28 commission.
No, that's all right.
Ah.
So you have given them time to 2020. Did you consider the letter?
Yes, my lord, we have given the time up to the first of March, last paragraph was 50, page 274, my lord, 1 to 3, 4 for it. Correct. Here, we request you to complete 4 paragraphs, the BBB.
Yes.
We request you to complete the entire job as per provision of the contract within first March 2020. Failing which we shall have no other option but to take Yes. And my lord, in our affidavit in opposition, my lord, we have put it, my lord, there is another communication of March 7, March 7. Okay.
Just a minute. What is it? Yes, sir. Commissioning. We are ready for commissioning of the compressor. Will be completed by 28/2. As you have said, we decline to depute our officials to Procurement for inspection of these civil.
Then your lordship kindly keep this 440.
You see, as far as this Bagjan was concerned, it appears that you should have inspected the site.
My lord, given the time of the first of.
Huh?
We have given the time of the first of.
Not the entire project.
Of course, my lord,
For the entire project, only for this Bagjan,
my lord,
they said that it will be completed, including Bagjan basically, completed by 28/2/23. That is prior to March, prior to 31st March. Prior to
First of March.
1st of March.
they could not complete my.
No, but where have you said they could have, but you have said for the entire project, not
My
for
lord,
the.
that letter, your lordship will find that.
Of course, the one that page 244, I don't think it's proper because you have not even started the other.
The 7 March, my lord, the communication is there, my 7th of March.
7th of March, yeah,
Find that is 445.
7th March.
In our activity operation, that is running page is 446.
445. Four 45. Four 45. Yes,
To measure data engineering and construction. In spite of recording urgency for the assigned gas compression service to the compression of our from the very beginning, and despite our repeated appeals, follow-up, reminders, and heavier review meetings, in the concept of the audit, we have failed on all accounts to complete the mobilization any of the 8 locations. Even after the lapse of almost 1 year of this case, you have immediately failed to honor the conceptual commitment and in your subsequent repeated assurance to stop the job under the contract. Notwithstanding all our previous correspondence received in this regard, we had given you one last opportunity by our email dated 20th of February for the to complete the mobilization activities in entirety at all 8 locations positively by 1/1/2023, which again you failed to. Now we have confirmed after almost 1 year before to have discussed 2 more compressor packages in addition to the 3 at site functional unlimited bar charge against 3 locations only. So message is silent about 2 more compressor packages lying at Asansol. Regarding those 2 compressor packages, we have been able to understand by your vendors and Joytech engineering that they will not leave the same unless we clear their brain. And considering your letter type that are good, the next besides the financial box to help the account.
please correct. Okay. So,
Pilot, one thing. That page 224 assumes very much significant difference. That if we install one, it
no,
amounts
but then that laws cannot be actually, though it's there, it cannot be, it's
No,
not,
but-
it's not a workable
Here is
law.
the case
Ah.
where even Supreme Court's law of limitation was stopped. Because COVID in 2.5 years, COVID intervened.
No, but
Let
the
us
fact,
not forget that. No, what I'm saying. So look, and listen. End of the day, that minutes of 3 to 25, have they not, my lord, waived their right? What is in law, what is the meaning of that, my lord, minute proceeding?
the minutes, the meeting.
Yes, that,
No, I'm not on that.
See?
I'm on that, this is that 224. That is, one is commissioned, all is commissioned. That is not, I don't think.
what I say, my lord, if we start there, it will amount to commissioning. No. See, kind of-
Commissioning, cannot be commissioning of all.
No, it will amount to operationalization of the project, of the contract. Kindly, Lordship will kindly give it. It is in that context, Lordship will see. Now, my lord, on page.
I think I'll give some more time, no time.
Oh,
I've got orders to pass in his case. I've got 3 orders to pass.
Lordship will have it on some other.
Full bench. Full bench matter also, I've got no time.
Lordship is totally.
Totally filled with their cases which they will want to go in appeal. Huh? Okay. As we'll have to, we'll keep it as partners, but
Yes.
I don't think whether anything further is there to clear.
they all will want to say a little bit, I think.
No,
he
no, I have
wants
to say, well, because every
Yes,
time
sir.
he's something saying we can new.
That
So I
is,
have to
that is
reply.
the problem, both of you have not completed.
Then because I was in a haste to make my subsequent.
You can make.
So, my lord, next date, let my learned friend complete, then I'll give it. Instead of this piecemeal.
That's right, sir.
28. Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. P. Kaushik, for the petitioner. Mr. M.K. Chaudhary, lawyer, senior counsel, appears for Oil India Limited, assisted by Mr. K. Karita. Ms. A. Biani, no, not required. Oh, the Mr. R.K. Batra appears for the respondent number 3. In IWPC 5309/2023. Right. List this matter on 28. Huh? The order dated 29/4/2024 needs to be clarified. In as much as there has been, in as much as the submission, then no, it's as much as the observation made therein that the operation of the air compressor in Bhakjan, Balimara, Bethulijan can be completed within 24 hours, and in respect of Tabua and Barekpuri in a week's time, has been made by Mr. K. Chaudhary, learned senior counsel for the petitioner, and not by Mr. M. K. Chaudhary. Okay, one thing, wait. What were the three, the three, Pakistan, Balimara, and Bengkulu Jan, okay.
Yes.
These are- And which one is the one with the law and order problem?
One thing. Law and order, my lord, is with respect to Bhopal.
How do you spell that?
Phogpar.
Phog,
Par.
PARA. PARA. Oh, para. And the land acquisition is with regard to the other.
1 second. Okay. It is Ecom and Hathian.
Huh?
Ecom, EIKOM and Hathian.
Spelling?
Hathial.
ALI.
ALI.
Hathian.
And
Hathian.
Ecom, EIKOM.
Okay, the 24 hours. Bhakjan, Balimara. And one, but I've heard it so much. I hope I still remember. This just tell me that. This has to be here. I'll keep it with this. This has to be- you get that. Any more matters?